about rights organization and team. Thank you. May I call on Pastor Clement Ayola to give us the opening prayer?
Praise the Lord. Please let us stand to our feet for a short prayer. Father, in the name of Jesus, eternal rock of ages, we honor you. You are the judge of all judges and advocate of all advocates. Father, we thank you for this summit. We thank you for the godly mercies granted to everyone that is here today. We thank you for organizing this program, Father. We thank you for the life of all the participants. Let your name be glorified in the name of Jesus. Lord, we hand over this program into your hand. Father, come and take preeminence. At the end of this summit, we also separate Ekiti states, better Nigeria. In the mighty name of Jesus. Everything we are going to say, we are going to discuss today, at the end of the day, let your name alone be glorified. In the name of Jesus. Lay your hand upon all the people that are here, and at the time when we are in back to our destinations, grant us your mercy. Thank you, Father. We will remember today for one act of testimony. To your name, only, Father, be glorified in the mighty name of Jesus. Thank you, Father. In Jesus' name we pray.
Thank you, sister. We want to recognize the presence of the representatives of the Nigerian Correctional Center with us. You're most welcome, thank you for coming. We'll be calling on the Honorable Attorney General and Commissioner of Justice Ekiti State now for his welcome address. Join me to welcome Daya Atasina, Advocate of Nigeria.
Very active citizen of Ekiti State, honored participator in doing the keynote speaker, Honorable Justice Osho, my Lord, Honorable Justice Akintaya, my Lord, Honorable Justice Johnson, magistrates of the Judiciary, customary for President, former Attorney General of the State, Mr. Olushiri, the second Vice President of the NPA, the Dean Faculty of Law, Professor Ifemi Abdulhari, the Solicitor General of the State, Mr. Babishir Abibadesi, the Executive Secretary, Directors in the Ministry of Justice, leaders of the bank, commandants of Amateur, ladies and gentlemen, and also the RRS. It is an honor to welcome you to this important summit on administration of justice in the theme, attaining best practices in the administration of justice in the state. So once again, paradigm shift. We gather there not just as representatives of our respective offices and institutions, but as partners in the local process of justice. The administration of justice is a critical component of any society. Ekiti State increases as it ensures that justice is served and the rights of all individuals are protected. Today we come together not only to reflect on our progress in the administration of criminal justice, but to engage in meaningful dialogue about the future. Over the years, Ekiti State has made significant strides in reforming our criminal justice system. The passing of the administration of criminal justice law in 2014 marked a landmark movement in our effort to enhance efficiency, accountability, and transparency within our courts. This law has facilitated the expedition of trial cases, reduced the incidence of awaiting trial, promoting the rights of the defendant while ensuring justice for victims. This, however, does not mean that our criminal justice system is free from peculiar challenges such as overcrowded correctional centers, delayed trials, and inadequate legal representation for indigents, payment of witnesses and interpreters, visits of magistrate to police station in accordance with the law, setting up administration of criminal justice committee, and challenges of male prosecutors in the magistrate court. These and many others remain critical issues that underline the speed of our justice system. It is our duty to confront these challenges head on and seek innovative solutions that reflect the highest standard of justice. To address these challenges, it is essential to bring together stakeholders, both within and outside the state, to share knowledge, experiences, and expertise in order to attain the expected standard of international best practices. Hence, this summit is holding here today. Our discussion here today will focus on the key priority areas. We will explore ways to strengthen institutions involved in the administration of criminal justice, including police, court, and correctional services centers, with a view to overcome challenges within the system. Furthermore, we will discuss and develop strategies to promote accountability and transparency within the criminal justice system, and suggest innovative approaches and techniques that can improve the efficiency and effectiveness of criminal justice system. At this juncture, I would like to extend my deepest gratitude to His Excellency, Dr. Biodun Oyebade, for his unwavering support and commitment to advancing the administration of justice in the state. From 2022 to today, Mr. Dr. has given his full support to creating an enabling environment for the Ministry of Justice to trial by giving approval for recruiting more lawyers for the ministry, release of funds for the regulation of the ministry, procurement continues legal education by providing sponsorship for training and capacity building in different fields of law for the lawyers in the industry.
You recall that last year, that's 2022, with the Ministry of Justice have been having 100% appearance in the appearances in the NBA. Just like we got another approval for 100% appearance of NBA in the August meeting of NBA. And not only that, this approval also extends to even the lawyers in the essays, in the ESCO, and also all the organizations who are lawyers in the city. Let me also extend my warm appreciation to the keynote speaker of this summit, my Lord, Honorable Justice Rahman Adesina. Incidentally, when I was trying to introduce my father at Saturday, one of us, because we almost, I think it's 5% of the judges here, we are doing thank you very much. Justice is in this introduction. It's a formal series of native record. Justice leadership and expertise are everything. He is involved in several committees within the Lagos State in China. He shared the committee on key findings in the magistrate court. The chairman on the committee of official court reporters, also the chairman committee on bail information management system, and the remote hearing committee, vice president on the small scale court committee. My Lord, thank you very much for coming. Let me also thank our moderator for this summit, Professor Daniela Anambesi. Professor Daniela Anambesi is the president of Nigerian Branch of International Law Association. The International Law Association commits the study, clarification, and development of public and private international law, and furtherance of international understanding and respect for international law. Ladies, thank you for coming. Let us inform this that we have assembled this contact who are judges, lawyers, and key professionals of law, and I think this will also add to this summit. And I also acknowledge the special presence of my Lord, the acting CJ of the city, Honorable Justice A.L.W. and all the judges here present. Thank you very, very, very much. And my Lord, the Ekiti State Customary Court of Appeal, Honorable Justice M.O. Abadu, incidentally, you have to travel for another official assignment. And my Lord, and other judges here present, your worship magistrate here present, thank you for coming. Let me also thank the leadership and members of the Nigerian Bar Association, branches in the state here present. Thank you for your commitment and thank you for coming. Like I said in the last week, when you, every time you come to the Ministry of Justice, it's as if you are part of that. I really want to appreciate your commitment for the acquisition of justice. That is for the three branches of the NDA. Thank you very much. My application also goes to the Social and Family Secretary, Ministry of Justice in the State, directors and other members of staff, Ministry of Justice, members of the organizing committee of this summit, representing security agencies here present, and please permit me, I really appreciate your coming when I was recognizing all of you. I don't have all the lists, but I can see the other, I can see the police, and I can see the. I just thank you very much for your coming. As you will see, let us bear in mind that the path of reforming our criminal justice services is connected to that requires the active involvement of all stakeholders. Together, we can create a framework that not only upholds the rule of law, but ensures that justice is accessible, targeted, and available. I wish all of us to do and rewarding the nation. Thank you very, very much.
Thank you. Thank you, sir, for the welcome address. May I give you opportunities to recognize the presence of my Lord, Honorable Justice Dele Akrabi. My Lord, thank you for joining us and welcome. We have the representative of the Nigerian Security and Civil Defense here. Thank you for joining us, sir. Thank you for being here. We have the representatives of civil society organization in the state. Specifically, we have the director of JDPI Justice Development Unions, here, Mr. Akwabi, I'm sorry, my lord, Mr. Omaleke. Thank you for joining us. We are going to be moving now to the address by the acting chief judge of Ekiti State, my lord, Honorable Justice Stephen Odumoye. My lord, you're welcome to the program.
Leaders, learning academy, we have committed to standards already established. Commitment is especially welcome because it's leadership judiciary. When I saw this morning, I knew MOJ will make this. When you talk about the digitalization of the sharing, that is it. I know we will have a large amount of people. You are welcome to because I'm definitely delighted to be part of this stakeholder summit on addition of criminal justice in the state, organized by the State of Justice in collaboration with the Nigerian Bar Association of the state. This program was not the first of its time. I recall the story of the first administration of criminal justice summit in the state, hosted by the Institute of Justice in the 2000, when the state was just responding and the robust engagement there, as well as the follow-up roundtable meetings, which laid a strong foundation for the reform initiatives that culminated in the repeal of the criminal procedure law and enactment of the administration of criminal justice for 2014, and the repeal of the criminal code law and the enactment of the criminal law in the state 2021 in Bolivia. The several innovative provisions of the enactment had a priority and a transition from the old, outdated, and ineffective substantive and agricultural criminal law routine to a more relevant, more proactive, user-friendly, and effective regime with friendly best practices. It is notable that similar efforts and initiatives of the federal level also culminated in the enactment of legislation such as the Evidence Act 2011 of Amendment, and the Criminal Justice Act 2015, Violence Against Persons Protection Act 2015, the Nigerian Correctional Service Act 2019, and the Nigerian Police Act 2020. All these legislation which were a product of combined and spirited efforts of relevant stakeholders to address those challenges to effective and efficient administration of criminal justice in Nigeria also contains several innovative provisions with vast potential to guarantee and facilitate a better system of criminal justice administration for the betterment of the society and for the benefit of all. While we must commend the statutory and institutional reform so far at the state and federal levels, nevertheless, we must frankly admit that our criminal justice administration is still bedeviled by serious and seemingly intractable challenges tending to overshadow and undermine the progress made. The problems of victims foundation, delay in trial, human rights abuses, and violation through investigation, infrastructural deficiencies, etc., which have characterized our criminal justice administration over the years, and even before the external reforms have stubbornly refused to pay them. Rather, we have continued to fail the system and appear relevant to genuine and concerted efforts to solve it. Furthermore, several provisions in the laws and the applicable rules and practice directives aimed at addressing this problem, particularly with pre-bargaining, alternatives to imprisonment, investigative protocols, demand protocols, sentencing principles, and guidelines weakness of community protection, dishonesty justice, lack the necessary policy framework and institutional structure to facilitate the effective implementation and are thus unable to use the desired result several years after the enhancement was made. However, despite these challenges, we cannot retire or relent in collective efforts to search a way forward in ensuring a working criminal justice system that is capable of delivering the dividends of democracy to the citizens. To this end, the summit of this time is not only silent but imperative, as it provides a veritable platform for open, frank, and robust discussion, pertinent issues, and proposals for workable solutions. I therefore wish to commend the Minister of Justice under the leadership of the Attorney General and Commissioner for Justice, Mr. Tayo, SA, in collaboration with the MDA, organizing the closing summit. I believe it is a step in the right direction, and it is my hope that the outcome will be positive for all. I also wish to all justice holders and participants in this event to endeavor to be active to contribute silently over the achievement of the purpose of this program, which is to explore and exploit ways and means of strengthening our criminal justice administration institutions, promote accountability and transparency in the activities and operations, promote and protect human rights, and discover and embrace innovative practices that can enhance their greater efficiency. It is on this note that I now have the full privilege and honor to declare this summit open. Happy and successful dedication. Thank you.
Thank you, my Lord, the acting CJ of Ekiti State. We are moving further in this program, and it is my great honor to respectfully read the citation of my Lord, Honorable Justice Raymond Chuku. My Lord, may I humbly request that my Lord rise as I read the citation. I'm most grateful, my Lord. Honorable Justice Raymond Chuku presides over the special and sexual offences court of the High Court of Lagos State. His Lordship has a solid educational foundation, having earned his law degree and a master's in law from the University of Lagos. Justice Osodi's exceptional contributions to the legal field have been recognized with numerous prestigious awards. Notably, in 2022, he was honored with the Award for Judicial Excellence from the Nigerian Bar Association, Lagos branch, a testament to his outstanding performance and dedication. Before his elevation to the High Court bench, his Lordship received two special recognition awards from the Presidential Enabling Business Environment Council in 2019 and 2020 for his role in training magistrates and court registrars in Lagos and Kano cities. On the small claims front, the awards were presented by the Vice President of Nigeria, Professor Yemi Oshibanjo, Senior Advocate of Nigeria, GC Morgan. Justice Oshodi participated in the 39th Cambridge International Symposium on Economic Crime in September 2022. His Lordship is the mandatory reviewer for the Journal of Financial Crime and Money Laundering Control, contributing to the global in the Magistrates Court, the Committee on Official Courts, Reporters, the Committee on Bail Information Management System, and the Remote Hearing Committee while serving on the Small Claims Courts Committee. Ladies and gentlemen, I give to you Honorable Justice Raymond Chuku. Thank you. May I welcome my Lord to the podium to give us his keynote speech. Thank you.
Good morning, my Lord, the acting people, my Lord, represent the Honorable General. Sorry, I almost lost my voice yesterday when I entered the meeting. Because the last place I did in the state was before my Lord was Akitayo, and I lost place. And so that happened. That is the reason for the I'll try to keep within the time given for this presentation. Many people have got the already existing protocol and established by the local attorney general. I'm honored to be invited as the keynote speaker at this summit. I bring greetings from Lagos State, the Center of Judicial Excellence, where we have been implementing reforms that have yielded measurable improvements in our criminal justice system. But I must say, in the state of my experience here, there is a lot of judicial advocacy, which I deeply appreciate. My address aims to give insights from our experience. I'm going to explore strategies that will enable us to expedite criminal trials, to decongest the custodial center, to develop alternative custodial sentencing, and to take care of the vulnerable persons in conflict with the law, that is children. The theme of this summit is very instructive. I am going to highlight some of the challenges facing the criminal justice system. I will offer some suggestions and I will take discussion in each of the critical areas identified by the organizers of the summit. I'm very confident that this summit will yield resolutions and actionable recommendations that will ensure that the way we deal with our criminal justice system going forward will improve. I've said that the path forward begins with our deliberation today. It is my hope that whatever we deliberate today will resonate generations to come. The first part of this keynote address deals with the criminal justice system in the Ekiti state. The criminal justice system is a combination of four main factors. We have the judiciary, we have the correction, we also have the law enforcement. In the Ekiti state, it includes other stakeholders. We have their own technique. Their collective efforts are very crucial to the overall functioning of the justice system. I've cited the addition of criminal justice law of the state in 2014. I'm grateful for the DPP who shared a copy of the law with me. The law has a lot of progressive provisions aimed at enhancing the efficiency and effectiveness of the criminal justice system. However, significant challenges remain in the implementation. After reading the law, I realized that a lot of the provisions are not being put to use. Perhaps at the end of this summit, we can look for better ways to use all of those provisions. I've said that the law enforcement includes police, the economic and financial transformation. Their primary obligation is to maintain public order and to prevent crime and to investigate. We all know this, but there is a critical problem with law enforcement, and that's the lack of interagency cooperation. The EFCC will do their thing, the police will do their thing, custodial centers will do their own. I mean, in the case that is instructing, a man has taken money from different people in 2010, and they wrote different petitions, some to the police, some to the EFCC. He was arrested in 2010, but the other agency did not know he had been arrested. He was remanded in the maximum security custodial center, and they didn't even know. So one of the operatives went to court for another case. And when they mentioned the date, they said they had been looking for this man since 2010. That was in 2018, 8 years after. They took the statement form to him in the custodial center to write the statement. He refused to write any statement. In a nutshell, the case concluded in 2024. The complaint was made in 2010. Case concluded in 2024, 14 years. But there is a system we have put in place. The police can always check the records to know where a defendant is. I'll come to that subsequently. I've also said that there is a magistrate oversight function
It's part of the law, but it's not well in place. I'm grateful to value Akitade is here today. He has been pushing for Lagos State for the oversight functions. And I can say now that consistently the magistrates go from time to time to the police stations to see those in custody, and most cases they grant them bail. We used this during Jesus strike in 2021. Court officers were not working. As a result, police did not release defendants in custody. So what do? We keep them in custody until the court resumes, but the magistrate went to the police stations, granted bail to those that were entitled to it. As a result, we were able to get the custodial centers. We also used it during COVID-19 when the system was not functioning. The magistrate will from time to time to in collaboration with the NDA, with the legal council of Nigeria, and office of the public defender. They go there to congest themselves and announce. So the DPO would not even know they are coming, so that they don't go there and the necessary inmates release them on bail. The second part is the judiciary, which I'm part of. But the high point of this discussion here is that all decisions must be based on evidence and not sentiments. Now, there is a lot of discussion regarding court decisions. I mean, these days, the social media, bloggers will blog that the court decision of the Supreme Court is irrational. The lawyers will post on top of that blog, making their own comments, which I think is not the right thing, because the blogger is not a lawyer. What I challenge the members of the bar to do, when you see a decision that you think it's of public interest, get a certified copy of the decision, read it, then publish an academic article, you can publish on your LinkedIn profile, it's free publication. You can publish on academia. You must read the decision first before making comment. I read the decision recently of the recent decision of Sunday. You know that the conviction was upheld by the Supreme Court. All that was said was completely different from what was in the report. When I read it in the paper that what they need to not have done, they sent me a copy of the decision. At the end of the day, there was good reason for the outcome of that decision. I repeat, what decision must be based on evidence and precedent, not sentiment. And I always say, for the prosecution in criminal cases, the conclusion of the case is not necessarily what occurs. It is what the prosecution is able to prove. So many things that can happen if the prosecution does not establish it, the defendant will be discharged and acquitted. The correctional centers have said that the correctional centers they have an obligation to promote public safety, to rehabilitate. But I'm grateful to the custodial centers recently. During sentencing, I speak with a lot of the defendants because they are entitled under the law to make a statement. And quite a number of them have actually been reformed. Some have done their exam and were in custody. Some have left traveling. Some have become clerics. But I don't see any of this in the media. I have the correctional centers have a lot to do because when you inform people, it's a good story to tell the public. But the only thing we hear in the media is that correctional centers are congested. Somebody must put a narrative there. And it is very important so that we know that people are actually learning. Some have gone to National Open University. They've obtained degrees in study. The media article is in the public view. And perhaps that will also change the perception about the custodial center. I will now go to the challenges. We know these challenges. Law enforcement agencies are under-resourced. The high volume of cases in the court, limited infrastructure. From my experience in Lagos State, I can attest to overcrowding in the custodial center. Our latest data, one of the committees I chair, we have data analysis, and every month we publish the data. As of the 1st of March 2025, the Ikoyi Custodial Center with a capacity of 800 has 3,540 units. The maximum center with a capacity of 1,000 has 2,100 units. The female custodial center also has a similar data. Therefore, all of the custodial centers put together have over 200% the number of persons that are supposed to be there. But every day, you keep sending people there. I think that in the state, perhaps because of the discussion, we can share experiences, whether you have similar challenges. But regardless, it underscores the urgency of implementing alternative to incarceration. Not everybody should go to jail. Simple assault, we send them to 3 years in prison. You miss it in armed robbery suspect. It doesn't really, at this stage, we should consider alternative. I'm on paragraph 15 now. The policies we can engage in enhanced speedy and efficient criminal trials. The first one, if our criminal system works effectively, then the public will have trust in the system. Then I've gone ahead to now discuss all of the policies that we have in the Ekiti state that are not being used effectively. I'll begin with the first one, and this is the 2014 law, and we're in 2025, over a decade. We have section 262 of the ACCL in the Ekiti state. We have a similar law in Lagos State. It's about the same thing. It says the CJ shall assign a criminal case within 15 days of his filing. Then the judge shall ensure that it is listed within 14 days. We really use these tools in the criminal justice system. We have this problem with some of our, in Lagos State, some of our staff. The honorable judge will assign the case. Then the clerk who is supposed to take the case file to the judge will keep it. Then until they've assigned the cases, he will not take them to court. But that has stopped because the policy now is the case has been assigned on Monday. You take it to the judge on Monday. The judge will pass it to a date for Tuesday or Wednesday. So within a week, it's done. But in the past, when they will wait for 10 case files, if the judge receives 10 case files, you cannot give it to 10 case files the same day. And so that would also prolong the hearing of the case. I've discussed specialized court. The idea of having specialized court has come to stay. In the past, we had the armed robbery tribunal to deal with armed robbery cases, not armed robbery was a problem. But now we realize that sexual crimes have become a problem. Financial crimes have become a problem. And law and regulations governing this crime, whether we like it or not, are a bit more advanced. Well, this is not the forum for that, but it's important to have specialized court. It doesn't really mean that the specialized court will not get any other case, but the priority cases that will handle are the specialized cases. In Lagos, we have 41 judges in the criminal division. Then we subdivided the criminal division into 3. We have the general criminal division, they deal with common cases, armed robbery, kidnapping, cultivation, and all of that. We have the sexual offenses. They deal with sexual crimes. So if it's an armed robbery case and there was rape, it goes to the sexual offenses court. And we have different case file jackets for them. So sexual offenses have to go peculiar case file jackets so that when they are assigning, it's easy to locate. Then we have the financial crimes, we also have their own special file jackets. And so what we've also done is that the judges have monthly meetings in that division. We discuss all of the problems, we discuss the new laws, and we discuss on how to deal with them. So before anybody brings up a new case, we would have discussed it. We adopted the style that they call position papers. So a new law or a new decision has been taken. What do we do about it? One of the judges will volunteer to write a position paper. Any other judge who has a different view will write his own position paper. And we discuss this. At the end of the day, the law is usually based on precedent. Then we adopt a policy based on precedent. Not on the thing, but based on the new law and the precedent. And this is a good practice because when we amended the ACCL in 2021, before most of the lawyers started giving applications under the law, we have discussed it. We agreed to resolution, so it was easy to apply. Then we shared the minutes of the meeting to all of the judges in that division, and they look at it. Any new judge who said this in the division also received the minutes of the meeting. How this discuss the time limit for trial processing. Now, the 1999 Constitution envisages that a criminal trial is conducted, say, within 3 months, but it's no longer practical. We have the Addition of Criminal Justice Direction that says the trial should be concluded within 365 days. That again is no longer practical. From our experience with the Judicial Information Management System, we took the data and we realized that the standard criminal trial takes between 3 to 4 years to conclude. And for those ones that have minor offenses, that have minor punishment section like 3 years, they would have served the term before conviction. So we decided to apply the provisions of this law to the letter. So as much as possible, the party direction says the court should conclude cases within 365 days. It also introduced state management meetings, and it did not mean because the ACJL in the state has similar provisions. We have the procedural innovation. Now, the ACJL in the state says a criminal says in section 460 subsection 2 that an objection to the sufficiency of evidence shall only be taken at the close of the prosecution stage. Well, in Lagos State, we have a more robust provision in 2021 that says the objection should be combined with the trial and taken at the end of the case. Incidentally, there are Supreme Court decisions on this point. I've cited the extra investment limited and FRA, and Jeremiah and FRA, Olabuju and FRA. The idea of this principle is to avoid piecemeal litigation. Somebody raises an objection, you go to the Supreme Court, and you come back to start the case. These cases say you can combine in the main trial, but it now depends on the category of the class of the objection. Another innovation, which is also contained in ACJL, is section 273, which prevents stay of proceedings. I think that is also set in the law of cases that say stay of proceedings is no longer allowed in criminal trials. In the past, proceedings in the state, when they go to Supreme Court, they continue after 15 years. In Lagos State, we have a bit of innovation in the 2021 law that says trial and conviction in absentia. Now, initially, when the law was suggested, they were debated as to whether you can try a defendant in his absence. I've cited in the footnote the case of AJ, Otuneye, and FRA. In that case, there were 3 defendants, and it was before the Lagos State High Court. One of the defendants was E, and they agreed with the judge to continue the proceedings in that sense. The lawyer was present throughout the conduct of the proceedings. At the end of the day, when there was a conviction, they went on appeal. And the Court of Appeal held in 2014 that the trial in absentia was wrong because there was no law supporting it. Now we know why. So the ACJL handled the law that allows a trial in absentia. But trial in absentia is not applied. There are certain rules. The defendant must have been arraigned. 1, he must have been granted bail. 2, the court must have adjourned in order. This is court appearance at least 2 times. Then the court can proceed to trial in absentia and even convict in absentia. The same ACJA has a similar provision. A precedent, the Court of Appeal in Mena and FRA, which was by Justice Aban, now JCA. And the Court of Appeal upheld the trial and conviction of Abdulrahman Mena in his absence because he jumped in. So the law has come to stay. There are also certain procedural safeguards, for instance, on professional statement. Now, there's a lot of discussion about professional statement section 19. So many publications, and the Supreme Court has said it has come to stay. But I like the way they phrase it in the Ekiti state, which many other states miss that provision. In all other states, they say if the defendant counsel is not present, or there is no video recording, then the professional statement cannot be used. But in the Ekiti state, which is a very clever provision, which is used in Lagos and other states, there's a proviso under section 9 that says subjected to evidence act. It removed the debate as to whether it is the Evidence Act that gives priority over the ACJ, because the law in the ACJ in the state says recognizes the fact that Evidence Act regulates evidence. So we have made the law for taking our professional statement, but we subject our law to Evidence Act, which is a very novel and interesting provision. 10 years down the line, other states are still making new laws without this provision. As a result, thank you. A round of applause for you. And even the late legislature made an amendment in 2021 to now select a lawyer or external representative. But then they have let this law without PDPC. Unfortunately, we missed the quite an interesting provision. But regardless, the decision of the Supreme Court, and as the Honorable Attorney General said in his opening statement, to show that it is international best practice to video record or have the defendant statement taken in the presence of the lawyer. So whether we like it or not, these provisions have come to stay. But then again, I think the police is making comments. Have you made sufficient provisions for the police? Do they have video recorders? They don't. So what do? And the man says, I don't have a lawyer, I don't have any relative, I don't have any friend. Do they throw you instead of living there? Question mark. But then again, if the man says, I don't have a lawyer, I don't have a relative, let him write the statement. Let the statement be, I do not have a lawyer, I do not have a relative, and I'm not saying anything. You have taken a statement. It's part of the documentary evidence that I'm using for. Whenever I have a lawyer or you have somebody to witness the statement, then they can make another statement. But the police will say they cannot put a man in his cell if he doesn't make a statement. Even if it's one line, I am not making a statement because I do not have a lawyer, let him write it down. It's a way that shows the record, completeness of the record. Promoting plea bargaining, I think the Honorable Judge mentioned it. Now, there have been discussions about plea bargaining. Some say it is good, some say it is bad, some say it is of more than even plea bargaining. But the way we have used plea bargaining in Lagos now, it amounts to about 40% of the completed cases. Now, plea bargaining is a tool contained in the ACJL. What they did in Lagos is to set up a plea bargaining committee. They look at the case and even use it in other cases. Because the time it takes to conclude the trial is 4 years. If the man says, I'm guilty, it is a case of rape, I'll plead guilty to attempted rape. Whether I go to prison for life imprisonment, I'll accept 14 years. That is a good provision. Why don't we use it to be congested court? Why are we insisting on full trial? A trial that the prosecutor is never even sure you will win. A trial that you are not even sure will be upheld or appealed. Why waste our time? Because we do not want plea bargaining. By the way, the convicts and the victims, they also participate in plea bargaining. The Ekiti law allows for compensation in plea bargaining. Same as the Lagos law. So in cases of rape, the man pleads guilty to attempted rape and said I'll pay the compensation of 2 million. It's part of the plea bargaining agreement. It is acceptable. Why do we want to insist on full trial? Tomorrow, the witness will not be available. Tomorrow, the defendant and 5 or 2 days people will say the defendant has been in custody and waiting to that for many years. Let them embrace the bargain and show it. Now, what we also think in Lagos is that plea bargain, the sentence agreed is always premise at the time of the plea bargain. If the man pleads guilty immediately, then they usually go to this sentence. If they plead guilty after trial, then it is more. In any event, the plea bargain in which evidence has been given, we consider the competent evidence both of the lawyers and the court. So as I said, we have 40% of completion rate in the plea bargain that we have consistently do recently. It also allows the defendant to negotiate the outcome of his case. It will allow for payment of compensation and restitution. Implementing the alternative to incarceration, restorative justice. Now, initially, restorative justice was thought of, if it is a crime, you cannot do ADR. Restorative justice will be ADR in criminal cases. Professor Wasanoli yesterday gave a paper 2 years ago at the NNDC summit, and he suggested the idea that restorative justice could be used in criminal trials. Some said they were wrong, the criminal crime is against the state. But what we have done in Lagos, the only one who has set up a restorative justice committee, headed by a director of the Ministry of Justice. What do they do? It's a case of assault. We want to raise resources prosecuting the case of one man slap another in court for years. The restorative justice will call the parties to settle the mediate between them and settle. In some cases, it may result in a plea bargain. In some cases, it may result in outright termination of the trial. By the way, the police engage in this all of the time. The man makes a claim in the police station, police will call the parties and they settle. But the disadvantage of the police and the difference with restorative justice is that when the police do it, the parties will agree. Then after the agreement, they go to court and say police is not able to cover again. Now file in court to believe again the police. At the end of the day, court usually will uphold that position of law. But indeed, police is not able to cover again. But when they go to the deputy's office, they have the restorative justice officer who is the lawyer. They have an agreement after they have agreed. At the end of the day, it's not likely to be upheld and acceptable by the parties. And if the party, if the victim insists on a conviction, then they can take a plea bargain. But I think restorative justice should be used. However, it is used only for minor offenses, not serious ones. Then we have the community service. The ACJA has provision for community service. It allows for company to do community service. And the 2014 law. Is there anybody who wants to take the custody? Some are minor offenses. And the state must consider what it is. Because in Lagos, we have them who work with the people that shoot the street. They also have the community service units. And officers are attached to the court. The officer is always there, and the community service, and this is the process. A man is charged with a very simple offense, assault, or 250, after he is convicted by the court. Sentenced to 2 years imprisonment with an option of community or 2 years community service. At the point of sentencing, the community service hands over the defendant in collaboration with the custodial center, because they also have a limit. The offender or the convict will provide sureties for his community service. Then the community service unit will not engage him, see what he can do, then refer to the appropriate section of what he should do. That is very effective in Lagos. We have done over 500 community service, and you can imagine if those 500 people have been set in custody, so that may not more. We have also used it to congest the prison. As discussed here, treatment for juvenile offenders. Now, the Ekiti State ACJL in section 340 recognizes that some offenders may be young persons. So we say the court must conduct special inquiry. By the way, maybe because of discussion, whether you have a special center for remanding young persons. But in Lagos, a young person requires special provision for the law. We have the special correctional center for boys. I've had many boys come to that center. They have counselors. If you say you're a Muslim, they give you a Muslim counselor and a man. If you say you're a Christian, they give you a pastor to counsel them. Then we also have specialists who are going to train them and counsel them. At the end of the day, most of the boys that have come across come out before the day before. And it's also important to have a center for girls. So you have a center for boys, you have a center for girls. I think that they offer the opportunity to show young offenders into productive citizens. Then, as my Lord, the Honorable Chief Judge have accurately mentioned, I've also discussed technology integration. We cannot think without technology in today's society. We all have devices we use. Have you ever wondered how the banks and commercial institutions use technology effectively? than the public government institutions. In the past, when you go to a bank, number one, you have to go to your branch. Then number two, you have to take a tally number. Then you wait for hours to take the money. But now the banks have found a way to synchronize all the systems. Like I can transfer money from my phone. I can also go to any branch to take money. Why do we not use technology to aid our system? Public institutions. We are also in Lagos, and the use of technology will aid efficiency. This is what we have done. The ACDL amended says we must have a crime register. The Lagos State Criminal Information System. Now, a crime register is a register that has details of all the offenders in the state. And they use it, what they call the 4x4 442 biometric equipment. We sold for $4,200 in the open market in the US, but from China you can get it cheaper. So a man is arrested, he's taken to court. What do? You put his fingerprints and his picture. You know, I know DPPs will argue and hospitals. Whether a man is the first offender, I don't know whether this is here. I feel now successfully argued that the man is not the first offender. Yes, this will have to do, but now this will show whether it's a first offender or not, because the biometrics will be compared. When you go to the biometrics is also compared. We are doing this system successfully. Now, what we have also achieved in this system is gather data and for planning. And for the 1st of March 2025, our LCI showed that the highest amount of crimes we have seen in Lagos is still related to persons, 60%. And you know why? The country is hard. People are looking for what to eat. So they still, obtain what they are eating. All of that is 60%. Followed by breach of the peace, which is 15%. Followed by sexual offenses, which is 6.1%. But by the way, sexual offenses, the empowerment is the highest. We've also now developed the area in which crime is being committed. Provided there is a conflict, because for cases being investigated by the police, they don't have the equipment, so the police don't have the data. But what we have done in the court is to have the data. So unfortunately, the data does not include cases that were reported at the police station. No. The data is limited to those cases that are documented that biometrics have been taken. Perhaps, and I've suggested that we should have a robust system where the police division will have the data as well. So everything is in that system. As of the 1st of March, when I spoke at the Lagos Justice Summit last time, data showed that the highest crime rate center was all over the media then. For NAC and moved. As of the 1st of March, highest crime area in Lagos is Ekiti, 20%, followed by Lagos Island, 18.2%, followed by Ekiti, 15.9%. Of course, these are the commercial centers in the Lagos State. Additionally, we also know the location of the offenders. There's a lot of stuff in the media about terrorist suspects and kidnappers. Some will say they are from this part of the country, others will say they are from another part. We don't have data. It's a responsibility of every government to ensure that at least in the custodial center, you have arrested kidnappers, you are trying them, you must be able to show how many of them came from one part of the country. Because when they make a statement, police statement form, they have to put where they are from, whether they are about their answer. When they go to the correctional center, they will say where they are from. You can collect that data and say, between this time and this time, we have arrested XYZ kidnappers, and 3% of them are from this part of the country. But we don't. When there was the election of Lagos, the presidential election, there was a lot of news about the people committing crime in Lagos State. Some say they are from this part, others say they are from this part. So I thought that data analysts to go to the prison to check where they are from. When I presented at the Lagos Justice Summit last year, the highest number was individuals from Lagos State. connect and not a bit. Ogun State, 25%. They are all people. Oyo State, 24%. And Lagos State, 6.4%. I don't have Lagos State. I don't have Kaduna State. They are all people that are taking from last state. Incidentally, local round of also Ekiti. It's among the lowest, 2.5%. But Kano State is going to Lagos State, 1.7%. Now we know where they are from. It's important for planning. It's also important for reality in the media that these are the people committing crime in Lagos State. When the people in custody, 2.5% are committing the state, 1.7% from Kano State. Why did you say the man from Kano that is committing crime in Lagos State? When we have the negotiation at 6.4%, data is important for planning. We have also used it to capture defendants who are evading trial. I'll give you one case. A man brutally raped a 13-year-old girl in 2015 in Moshi. He knew he had committed the crime. They put him in the police procedure. 2015, 16, up to 2019, he never showed up in court. So the judge got out the case. In 2024, his name came out on prison congestion list. So when the name comes out, because they have data, we separated among all the courts. And we found out that it was in my court. So the DPP had to file had to apply to the list. As far as adopted in 2024, incidentally, the victim and the parents, they were worried because they thought the man had gone free. They started the trial in 2024, concluded in 2024, and the man was convicted in 2024. I do not have this record. They would have said, particularly people would have said, the man has been in custody since 2015, directing trial. They will release him to go and be offended. But we have this data, and so it's important when the media say people are in custody without trial, some of them aren't. They don't go to court. If they don't go to court, how can we try them? They went the NBA committee on human rights. In all of the stories, then they say the judiciary is bad, the government is bad, the people is bad, and so it's important we have this data to corner them. This very thing is another house I came out, and I identified part of them. You were listed for physical congestion. Part of them yesterday evening, they added to us and report for years. They are not going to court for years. Now, about the we also showed that 64% of sex-related cases involve the partner protocols, and the men who are committing this crime are between the ages of 26 and 65. So when we have the law that says the men is punishable with life imprisonment, there's a reason for it. Because so that 1 year old, 3 years old are being debarred, by the end of 26 to 65 years, we have the data, and when the legislator wants to amend the law, they can use the data. I totally recommend that the legislature should have a similar system. All you need to do is start the corrections. They call all of them and take their corrections. Once you are done with that, you start with putting up to that case and they take their corrections. Once they are done with that, you now go to the police station and take their corrections. That will control everything happening in the state. We also have the main information management system. This is another very interesting committee, which knows the professional committees. Now we stand for a fee. Now we can get in because we take that objectives. Once we take that objectives, we become the main to show. Then we have also got ahead to connect it with Google Maps. So the man says, I will be Abara Estate, and it gives the address. You can check to see located address. That is if you want to, but ultimately, the person of having all of this address is no longer because the man has a national application number. It is put on this system, and the address has been provided. So the very information what they have done, what judges and administrators are going to be paid because they know that the shorting will not be professional. They also know that their place has been properly verified. And most importantly, they know that it is linked to the NIN. So you can always ask it to show us. And before the NIN is linked to your BPA. So like in the case that says shorty should not go to prison for standing as shorty. But now we have the system already show that the shorties are held accountable. So in one way, that system is the funds scheme. The state law has it. 1938. One scheme is where the courts, the CBA will register personal company who are able to organize themselves and stand as shorting for people. The deputy for the report, the shorting laws to pay. What we are also from, dependent on the scheme. So all the dependents they take their refuge. I think I said that before. Inmates for attendance. So for a lot of inmates, they do different reasons for not coming to court. Some will take the prosecution, some will take the court. Now at the end of the case, the court the conflict. You will endorse witness was absent. You will endorse the federal law of record. At the end of the day, you know why cases are not going. Whether the fault of the prosecution, the fault of the defendant, or the fault of the court. I also discussed recognizing possible technology. And then we start with the ACDA. Say the court will write the evidence. So that one says every God can write. But and then we don't write a person that has passed in court. In Lagos, we have the court of proper unity. And that's it. This is the incident report is happening. Audio and transcript. If the witness writes, it shows. If the lawyer can show the court, it shows. At the end of the day, when the court will transcript, it's second. That is more transparent. Remember when I was in practice, some lawyers will say, I want to talk to the court. Don't need to bother that anymore. Because the court has recorded you. Some will know you know, also to say, I want this court to be told me. But the fact that I think I want this court to be told me, it's okay, I'm going to say. They told me to accept it because they look like an act of money. At the end of the day, you meet yourself and you're embarrassed. Sometimes I can transmit, I shake my head. All I need to do is to transmit the ethics committee. And the lawyer is also repeated about the critical code of conduct. Then there's a new right in town because of artificial intelligence. It's called the scriber. The scriber works like nothing. Because when you report proceedings and all of the reporters we have, the intonation is not enough for my intonation because those speak English like the American speak. The scriber is designed to capture now all look out to me. And don't need to do anything. And you can work without the internet. Want to finish your study, send it to my top for 2 weeks. To finish your studies, upload it. It's coming. And again, we ask finding. We need to go. Ask for. Extra for the 3 months. So you can always get everything you do. And that will not hearing. You all know what hearing is. And rejected remotely. So what we have also done is to take our remote hearing to the particular center. So from the poor, go and set up with the possible so that they pregnant and have their cases done remotely. And instead of taking the next year, this time remotely, they don't appear in court. They appear in custodial center, they appear because they are taking it to them. What we are taking of the treatment against the custodial center. It's a simple thing like the Sabbath appeal. All they need to have their evidence and they have their four people. They have the skill. So you can take 20 minutes at the same time. You don't need to waste it for protection costs, people will all the time. The electronic filing and management. Now, we have been doing e-filing for a while in Lagos and in the aspect. But one thing we avoid is e-filing for criminal charges. No day, because of the government. One day, the people will pack 20 minutes, take care of them to custody, they call them overnight. The magistrate of the city is reporting. He wants to go at least 2 months at 2, 3 o'clock. They don't bring 20 people overnight, and the magistrate was here. And what happens? Demanded, demanded. It's not fair. What if I will do? The police want to find a case. Suspect is impossible. He has to make electronic. And when the time AD digital officer, the DPP is copying the filing because the DPP usually supervise this, particularly regarding the amendment to the Police Act. So once the time has been filed, the magistrate, the assigning magistrate has seen it, DPP has seen it. DPP can veto it and say this charge, I don't think it makes sense. Police should have to be part of something else because DPP has supervisory authority. Now, the assigning magistrate would have assigned to the magistrate with the charge. The magistrate would have taken a review and given a date. Then the police will give that person in that day. So no more overnight. If I ask you to come back 12 o'clock on Monday, they bring the plan at 12 o'clock on Monday. The magistrate already has taken a view about bail. And my poverty give them 9 o'clock so that 4 o'clock they would have done the bail. It's a fantastic system. We are working with that in the state. We need to put this along because the police will bring it to their facilities. All issues will happen. But there is more. What I am advocating is that this system and the ability should also, because technology is available to amendment, it should also be devised in such a way that once a police is taking them, because the law is there, it says the commissioner of police case class 5 of the commission to the attorney general is there. But the commissioner of police is not having. There are many police divisions. When they have to start accepting the case class office, what do they do? Once the police investigating the case, they are uploading it to the system. The man is a professional statement to upload it to the system. The DPP sees it. The video recording is uploaded. The DPP sees it. When the defense and find a case, it's not to compare the law. They are giving that to the whether I go to profit or not, then the DPP have a record of it. You have to file this story, everything on the record. When they want to take the issue legal advice, you don't need to come for the case anymore because I will have said so legal advice will be issued almost immediately. It's a system that can work. All we need to do is to collaborate with the police, train them and give them devices. So every single criminal trial in the case, every single person arrested, all the police they are doing their work, they are uploading it for the people to see. And they are also indicating that Like the banks do, if I open an account today, the bank says, and then for your project, 20 years time, they can get the account open information. It's easy and very easy. And what they do when police are investigating or PSC, they don't write to the bank. I need the account open information of Mr. A. That's all. And they provide the DBA. Even if the account was opened in 1990, the bank they have migrated all the transactions and they put it. And the bank will simply download and do a certificate of identification. That's all. But now, the bank asking that the government is looking for a case file and they cannot find it at this stage and time. But the bank will never look for account information or find it because they have embraced technology. So, this digitalizing system in the United World must be embraced. It will make it, and it's not as if the DPP is taking over the police world. But regardless, the attorney general and the chief officer of the state is supervising every criminal case in that state. So he must understand what is going on and what is not going on. He also looks for data. We can now have our own report and take in an evaluation. Our section 24. This is which you advise into that advice. I said it is encouraging experience and accountability in the now represented this for the consultant that said the product is very easy to embrace, it's also very easy to amend. And all of them have been saying also one thing. Collectively, we enhance public trust and confidence in the criminal justice system. When citizens witness the transparent processes, clear outcomes, they are made in the system rules. We are going to see a reduction of the social media classification of the judiciary because the system is transparent. Technology integration improves accountability and reduces opportunity for manipulation. While alternative to consideration of state systems into rehabilitation, I've also said that modern modern technologies, which is very basic technology, can also be deployed to each work of governments. Together, these reforms show citizens and the criminal justice system is evolving to meet their needs to uphold the fundamental principles of justice. I come to my conclusion. I've said the criminal justice system is more than a collection of institutions and laws. It is stated in the evident. The law is over almost 11 years old. We have not implemented up to 50% of the laws. Law is an embodiment of our commitment with equity. From Lagos State are not made technical adjustments. The path forward where it is stated not in adopting solutions from elsewhere. We don't just say we want to adopt solutions, but in thoughtfully adopting problem approaches to the unique context of your state. The criminal justice system is ultimately measured not only by statistics, but the ability to inspire public intelligence. When the criminal is used fire, you trust in our institutions. Then everything is done. I've said that justice, as you know, justice is not something of any country. the first position you want to. And the former business then the highest position of the society to ensure that justice is accessible to all. Paragraph 68, my advice to people at Attorney General. And that's why this week. I said, "Hey, Honorable Attorney General and Commissioner for Justice, Ekiti State. Ekiti State has the opportunity to adopt the criminal justice reform, focusing on expedited and efficient criminal trial, the integration of technology and alternatives to incarceration utilizing the existing laws. And improvement to win the trust and confidence of the citizens. I'm confident the state can achieve this goal through the holistic and collaborative approach. I thank the Ministry of Justice, the NBA, for organizing this summit and their commitment to the fair and efficient. I also thank everyone, my local dogs, and everyone else for participating and for their kind attention. Thank you very much.
Thank you, Michael, for the opening speech. It would be great to this session of the actions now, but before we move to that section, we'll be calling on the NGO representative, the person who has not got time will be doing the address on behalf of the NGO. However, if you are not, please stop. If you are not present here today, that is a stakeholder in the administration of criminal justice in the States, and you're expected to participate actively in this like the administration of criminal justice in the States. So please, we're expecting your reactions. As soon as the NGO representative is from there, you'll be taking reactions from the public. And please note that your reactions are going to be visit to the administration of criminal justice in the United States. Thank you.
Thank you very much. The action team with the states, Attorney General, still gets the chance. You know, that not to see. That's one thing. All of those things like that. We learned a lot, really. And I will say that we will get to it. Through collaboration, we will definitely get to something. Before we move to the discussion session, I would love to look at my brother chairman. Now, that is how I sense from the back. I'll tell you the story. Mr. Have the son of July for acting as needed something. We rushed for more than 5 minutes. Unfortunately, Mr. interest as accepted at the stipulated things. The money that only to deal with him, I have a professional leading staff. Mr. Afolabi of Council, Mr. Afolabi has a relationship with members of the police force. He instructed them via a petition, charged Mr. Afolabi with the offense of fraud, attempted murder, and armed robbery. The police already prepared an application for a remand order, a popular campaign that we are aware of. And on the day of trial, the day of hearing the application, Mr. Alabi agreed in court, needed the magistrate. But the magistrate said, he doesn't have jurisdiction with state charges from which Mr. Alabi has been brought. He whispered, I will be prepared to preserve my job than to agree with Mr. Alabi's spirit. You know what is next? We was sent to the correctional center for legal advice. 15 months down the line, there was no legal advice. The lawyer of Mr. Lamy went to the DPP's office only to discover that there was even no file transmitted from the police to the DPP side. What becomes the fate of Mr. Lamy? It will languish here for as long as it takes, while we are sleeping in our houses, family members will definitely cry again. The question we are asking from the back is simple. How can we keep quiet when the bloody innocent person is the highest victim of our? When civil cases are automatically criminalized for the sake of money, how can we keep quiet when anybody, including myself, can be a victim of complaint any day, anytime? How do you want us to keep quiet when our own professional colleagues will be asked with the police and use their account to siphon money from the innocent person and deposit to the police, all in the interest of whatever? How do you want us to keep quiet when judgment is given and it takes us several months to get a copy of this judgment? How do you want the lawyers to keep quiet in cases like this? These are issues that we're track out at the discussion session. I appreciate the letter of Attorney General for this wonderful letter. Thank you very much.
Thank you, representative of the Nigerian Association. We'll be taking reaction from the general public now on the previous speech. Please, if you have any reaction, please raise your hand. The microphone will pass across to you. While we are waiting for that, please we will be inviting the Akinbade for his reaction. Father, please, you can come up again.
My lords, present stakeholders, criminal administration of communities, it's a pleasure to be here. My name is so every development and peace initiative. We want to appreciate the relation of my institution, particularly its references to the importance of the use of technology in promoting good dispensation justice, and particularly the need of having good record of data. And that is why I have the pleasure to share with you that we, in the justice development is one of the areas that we have been working on with the officers of the operational center. We keep from time to time the records they give to us, the data of inmates at the operational center, and which we try to analyze in order for us to be able to understand the state of things with regards to the inmates and the operational center. Just briefly, in 2023, we started the business schooling in the year 2024, but based on the record that we were given in the year 2023, we have good this report together, showing that altogether in the year 2023, the admitted units were 649, and we are particularly interested in what we call attention to engage the engaging targets of the occupiers of the conventional center, which looks like about 80% of the correctional center of the ages under 21 to 50, which we regard as a working age that contributes meaningfully to the development of the state. And also, from our own study, we discovered that so many women are spending more than 1,000 days, 1,000 at the correctional center. We have had interaction with the Ministry of Justice, with the Office of the Attorney General, and we have had interaction with the judiciary under the leadership of my Lord, the Justice who gave us the sworn officer to work with so as to be able to applicate judiciary. But so far, we still enjoy the full support of the correctional center, and we have come out to see that what my Lord Justice we have said is certainly possible if we are interested. We at the Justice Development and Peace Initiative, we are prepared to make our own contributions to ensure that this is achieved. For year 2024, this can use solid. So for year 2024, we can see almost like over 100% increase in the number of females that were arrested for stealing. So from our chart, you can see that stealing is a prevailing circumstance in our society. And so possibly, appeal to my Lord, the acting chief judge, the office of the Attorney General, to please ensure that we have the Administration of Criminal Justice Committee that can be looking at this data from time to time and make policies for improving the administration of criminal justice in our state. Thanks for the opportunity.
Thank you for that, please, we are waiting for reactions. Please, can you pass the mic to Mr. Lawal? Is who has the microphone?
This motion, distinguish Mexican, all of I appreciate in this position West National without the people of the how about the do about the organization of justice? Effectively, as a question to the state, but the body instead of the building suspect report, and here, it is all overnight. You don't let me actually possible that you talk, latest, and then the but this is that 2 p.m. is the building. That is the tradition of the state. Understand? Secondly, too, I'm afraid if the correctional center actually represents its name. In most cases, they will not come to court with the high court of the 10 a.m. And this frustrates the Department of Public Prosecution
and even private lawyers, and even the court. The situation whereby the judges will have to wait until after 10 when we release somebody from prison. What we are taught in those days is that it is not the duty of the court to be waiting for litigants. It is for litigants to wait for courts. So I think there's a need to make necessary correction in this aspect. The correctional center in Ekiti, where it is up to the high court, it's not about to 30-minute drive. And that's the truth. So there's no reason why we cannot bring the email to top premises later by 8:30. There's no reason, no justification whatsoever. Let me start as it is too. We observe few of us who are not other specialists in criminal matter that at times when people are arraigned in court, the police will only give me few charges. Not minded of the fact that each of the defendants is entitled to a copy of the charges. So now become a problem between the wrestlers of court and the lawyer who's appearing. So, I think this ought to be corrected. Now, to the major issue, we are complaining that the prison is overcrowded. The question to ask ourselves is that who created the overcrowdedness of the prison? The police will bring inmates or suspects of the violence as president. Other complaint. That is section 264. And the next thing is to be arraigned in prison custody. The question will now have to be, can we say that the section 264 of section 1 is not amounting to a whole nation? If it is the law that the court will not have power, the court will not have power. By the time the magistrate doesn't have power over the armed robbery, attempted murders of weapons. And if he said that the magistrate has power to say the person to be murdered, that only people understand. That cannot be. But the question will now have to be, the person look at section 5 or that section 264. Give the magistrate the power to put anybody that is not to obey. But in most cases, maybe because of the gap of magistrates, they hardly get assistance. And that's what is fine. Then you now have to look at it if the law says well. You have to consider the circumstances, the personality, the reasons. Then you are looking for the subsection 4 of that law. For somebody who has a law, before you can understand whether the application to be granted.
Thank you, Mr. Nawal. We need to take other reactions.
Okay.
Thank you so much. We have received Mr. Nawal's reactions and the others on the logistics, the police and the drivers of the forces. We want to recognize the presence of our online participants. We have questions. We will be taking their questions and their reactions. Please, anyone that is going to be taking that is going to be having these reactions, please can we make it as short as possible so that we have the time to take other questions reaction. Please less than 3 minutes. We have our Mr. Wuchumi.
Regarding this present. He has brought the serious with it information on the rate. I want to see there is really too much problem with human implementation. The only addition which I tell you to look in from the formation of the destiny is the issue of the public technology. Not only key file is also a C here, which will make it incorporation into our ECA issue of here in about this of the rest of the issue of the having the chairman of NPE, the chairman, wrote a on the issue of cake without looking at it. I feel created that maybe what I should be doing. Then there's a picture of that. That section is for to the beginning. This is here. So you put candle in that section will make benefit in all the person meetings.
Thank you, sir. Thank you.
And with based on I will give you two examples which are extremely important. In which clients who never committed any offense, any offense, are brought in national because those second times.
We are
So
moving.
I therefore submit that section totally different because when the police will be investigated, any capital not fighting case of criminal offense, they require it to use who will now charge after reading whatever is in the statement. And those that are not under criminal offenses have been brought to the system where they will not get immediately. Rather than bringing them because of those sexual administration, they now put on Kenya and the damage in places. And you said in the field, you that position of energy 64, 65.
Thank
So
you.
let him
Thank you, sir. I think it's not the way that most of people in the world because it's not a reaction to the reaction. We got a massive reaction to the reaction. If you have other reaction, please raise your hand. We'll be giving numbers to speak this session up. Before then, while we raise our hands, I'll be calling on the Dean of Faculty of Law, Federal University of Oyo, to give this reaction. So we have 1, please, if you have 2, 3, 4. 4, that's 5. Thank you.
observation that we don't mention anything about compatibility of offenses. As situation through having offenses the human one process well according to the modern criminal procedure code than the sound. And how do we implement the component of processes of criminal justice in Nigeria? Thank you.
Please, please, I'll call on them, wondering just secretary of the tax, or the, we get it, we say it is.
The after city, members fight to do it. I believe
what has caught my attention even before coming here, before I got here today, when I received this invitation, was the issue of this campaign. While I was on the bench, I've repeatedly made that submission that Funke is illegal. Funke in itself is a nasty and injustice. I've seen cases of land matters where people are brought to my court on bail and on inquiry, where hearing the bail, I discovered that no charges have been filed against them. Then what is the basis? I cannot put something on nothing and allow it to stand. It will never stand. Somebody, before you say that on arrangement, there must be a formal charge. It is circumstance in law, elementary, that any offense that is not provided by the statute is not an offense. Except that offense is provided for and the man is aware, informed of the offenses he has committed. But you don't throw somebody from K to prison to everywhere, and when you are hearing the application, you ask, what is the offense against this man? They say no offense has been prescribed. He is not charged formally before the High Court. He is not formally charged before the High Court or the magistrate. The magistrate who has sentenced him or who has said that he should go to custody and is not having a formal charge before him. I will join the chorus that Honorable Attorney General, you are in charge. This law you call the law of criminal justice law is not even as comprehensive as our former criminal procedure law. All those provisions that are very germane in the criminal procedure law has been abrogated. I think we should have the second read on this our ACCA something. And primarily, I'm pleading that that section that gave room for complication to be deleted. But
she's asking that how can HCJL address issue of food, aggressive and hostile manner security officers make arrests? We are now security personnel operating development in Nigeria. Our officers will be made to institution on the constitutional rights of those that they want to arrest. I think we'll be taking another reaction from my Lord, Honorary Justice Family.
The Honorable Artificial Judge, my brother judges, distinguished ladies and gentlemen, I foresaw this and I prepared my comment. If you go down memory lane, you know that there was a time the problem was the unconstitutionality of holding charges. It was a problem of holding charges that led to the reforms that culminated in the enactment of provisions on remand proceedings. I had counsel come to my courts and they equate the provisions on remand proceedings with holding charge. And I have to repeat them again and again that proceedings, the remand proceeding is not a charge. And it has received the validation of the Supreme Court in 252 versus Johnson. It has received statutory recognition in Article of Criminal Justice Act 2015. It is a provision of the statute made by our lawmakers at the federal level and at the state level. And I think that apart from the provisions of the Additional Criminal Justice Act and the Additional Criminal Justice Law, in Ekiti, we have the Additional of Criminal Justice Rules 2020 that talks about how to go about this issue of remand proceedings. There are remand protocols But it appears as if a lot of counsel, a lot of our colleagues are actually not appreciative of the provisions and intended of the provisions. If we say that holding charges are constitutional, we say that the non-proceeding should go. Then what happens to suspects who are still under investigation and cannot be kept in custody beyond the period prescribed by the Constitution? We are going to precipitate the future. There is a need to have a second look at the provisions of the admission of criminal justice law. But I don't think we should throw out the baby with dirty bath. We can look at the implementation. The problem is not with provisions of that law, the problem is implementation. And I know that a lot of counsel are not conversant with the provisions of the addition of criminal justice law 2014 as amended. There is an amendment to that law, particularly section 264. There are also provisions in the addition of criminal justice law to ensure that there is fairness in the application of the provisions, so that people will not just be remanded unjustly and improperly. And I think that's what we need to do now. If you have an understanding and appreciation of the provision, the addition of criminal justice law, the addition of criminal justice rules, then you discover that there's no issue about the issue of criminal justice.
We did have another discussion session where we've been taking questions and answers. So this is not the last time where you can make your mind known. So you may reserve your questions to the question and answer session for the discussion session. Please, I'll be calling on the representative of the Nigerian Civil Defense Commandant to make his reaction. However, please, if you have short time, make it short in less than 2 minutes.
Thank you very much. I would like to stand on the already existing protocol. My name is Deputy Commandant Olowo Shijeje Fence. I'm here to represent our State Commandant, Commandant Thomas Martins Eya, the State Commandant of Nigerian Security and Civil Defense Corps, the State Command. Nigerian Security and Civil Defense Corps was established by an Act of Parliament referred to as Act number 2 of 2003 and Act number 6 of 2007. Subsection 2 of that Act, the F, says that the Corps shall have power to arrest with or without warrant, detain, investigate, and institute legal proceeding by or in the name of the Attorney General of the Federation in accordance with the provision of the Constitution of the Federal Republic of Nigeria against anyone who is reasonably suspected to have committed an offense under this Act. To my chagrin, for more than 3 years, this Corps has not been able to exercise this section of the Act because the section has been placed on perpetual suspension. We are talking about administration of criminal justice today. And Nigerian Security and Civil Defense Corps is one of the prosecuting agencies of federal government. That if we cannot be able to exercise this section of the law for one reason or the other, I think this will not go a long way to deepen and entrench the administration of criminal justice in Ekiti State. But let me just say that I want to thank the new CJ and the Honorable Attorney General, the Commissioner for Justice Ekiti State, for what they are doing at the moment in addressing this particular debate. Thank you, God bless.
Thank you so much. We'll be calling on the first person, number 1. We gave out numbers, number 1. Okay. Please, can you take microphone to her? Please, 1 minute, a minute.
And Honorable X, please permit me to understand the existing protocol. In our commitment to comments on the recent implementing alternative to a constitution. Recently, I'm recently having a criminal case, and when I called my witness to invite him to come give me the evidence, he asked me, Mama, what is the decision? Because this is a case of a stolen motorcycle. If you like to own motorcycle, to walk aside to give money to support himself, and you say that on most of them, that motorcycle got stolen. The person is being held with the custody. The person got the motorcycle disappeared from the police station, and he still has to serve paperwork to continue making installments for the instant payment for the motorcycle. Technically, there is indeed need for a more flexible approach to justice, because we are talking about motorcycle. Is paying for it. He told me, I can't come to talk because nothing is coming to me out of the box. I told him, come to talk. And at least for justice, to force us to stop repeats of such criminals. Therefore, I'm supporting the speaker that definitely this restorative justice is something that can be brought to our heads. Thank you so much.
I thank you for this clear guidance, because my name is not even law, but I thank you. And I want to stand up in the total establish. I'm Chief Value SS. My intervention is on this demand on that procedure and what in charge. To my mind, it is like a sixth and have a justice. I believe my Lord, to someone brilliant job, I know him. That's very evident sufficient. But I don't agree with respect to him. I agree with the authority, this but then I think there was we should revisit that. Put me to prison or custody. Supposing I'm not better than guilty, but there's nothing that you can visit of me. What happened to me? Who pays for that? Release me of me. If me, rather than go to the because you put a special condition for me to make a soft serious. I told you, if I'm not going to go for me, you have to come back, bring energy and educate. That's the problem I stand for you. That can be now put me in the investigation for 40 days. And you do it again. Now, that's not justice. I want to watch. Even at that level, to have a review. It's not consumer, it's not unfair, not justice. Thank you.
Thank you so much. Yes, we can follow your reaction.
Thank you. I want to stand on existing protocols. Just as said, the fault is not in our staff, but in ourselves that we are not aligned. The fault is not in concern. It is in implementation. It is even the lawyer that implemented the epistle read by Chairman Ato. He implicated himself that a lawyer said, go and charge for this or that. Is it not a lawyer that did that? Is it concern? It is not concern. But the lawyer that goes and said, go and charge you for some offense that he would not be able to be granted there. So the fault is not in concern. But in ourselves, who implemented? Thank you.
Thank you so much. Representative of the Second National Nigerian Bar Association Vice President, Mr. Bayo Akinlade, for his reaction. We have so much reactions. We'll be taking everyone, and please let us note again that we still have another session where we can have our questions and reactions also. Please make it brief, sir.
Respecting my lords.
Please, can we have silence in the house? Can we have silence in the house? Thank you.
I wasn't really saying but my Lord is I mentioned my name twice, I believe. I felt that I was in a bit of a quagmire there. I think it reasons from the National Second Vice President of the Nigerian Bar Association and also the NBA Human Rights Institute. A lot of these conversations.
So tomorrow we'll go together tomorrow.
And we also having with all the vice chairman of the Nigerian Bar Association. We cannot fix this in this meeting. This problem did not start with this meeting, it will not end here. The Bar Association should be more effective in contributing to whatever problems we're having in the society. I'm thinking that the learned judge spoke very well about it because in Lagos, they constantly tweak these laws. It is not one big thing. We have a problem here. And with the bit of the comment in Lagos, the problem is the organization of criminal justice and monitoring committees. And essentially, saddled with responsibility of overseeing themselves. The CJ is chairman of that committee, correct? All these other things in this committee is not listening. The AG will send the representative, all of them send representatives. We don't mind pushing them because only in the fourth time, we don't report back. So I think we should reconstitute our NCGLC and we should make it more effective. The responsibility within the bar association.
Thank you so much. You may not have the Honorable Taxation Judge of Ekiti State, the Honorable Attorney General of Ekiti State. Mine is not that of reaction much. I noticed that when you made our registration this morning, there was no column for email. I think the paper, the newspaper is such, of quality that should be given to the participants. I don't think the organizers have a way of still getting it across the board. Thank you. Thank you. Thank you. That's well noted. We'll be sending the papers across to all the platforms and the judiciary will also have a copy. So it's going to provide. Thank you. Please, we have another reaction over there. While we are taking the reaction over there, we think that we have another reaction from online. I think your regent is just trying to mention the experience she has this morning in respect of the administration of criminal justice. Thank you. Please make up for that.
Maybe we need to stand on the very standing photo. It also needs to the court of justice fund in London. And how look at the institute of from K, either from K or the voting charge. The problem we are having is that it is quite hard to know that the police are undermining media. I'm not taking this for granted. The only way we can cure this problem into encoding our magistrate, because this matter will be taken to magistrate. The magistrates, they have the duty to look at the justice problem. Whether they can only play for order or absolute. That's the well, the problem is the movement is structured to support My lords, the Honorable Academy, Commissioner of Justice, and seek to move to stand in the system protocol. By the grace of God, I also have to the history of campaign in the Ekiti state. And the motive as stated by the system money is to avoid unlawful detention by the police. The Constitution allows the police to detain for maximum of 2 days. If there is no complaint has to be. What will be the justification for putting on the longer for 48 minutes? Investigation is still ongoing. The complaint is included to address the breach of the constitutional provision. And as I know, Ekiti State have done a lot to address the abuse of cocaine. Administration of Criminal Justice Rule 2020 provides that before cocaine is taken to court, there must be an affidavit, the statement of the defendant must be attached, and if it is said went further, that is why I won't accept the fiction of the NPA agreement. If it is said went further to say that before the magistrate will accept any complaint, there must be an evidence that the case file has been sent to DPP. So the story of somebody is reminded that the case file is not even sent to the Ministry of Justice, is not that from the Ekiti State. No magistrate has sent a complaint without proof of having received sent the case file to the Ministry of Justice. So the need for complaint no rest is to put the police in an helpless situation. Police is put in a very helpless situation. Case is under investigation. They cannot detain the phone they cannot charge the phone. So I support the view. Islamic Law of the Senior Government of Nigeria is the moderator for the sporting session. You are most welcome, sir. During the action period, we had the question of double team R4. Bango Senior Government of Nigeria, all the way from the very, very much for coming here with us. My Lord, we'll bring the microphone to the Lord. We getting the action from the floor to the platform.
before this is not if there's no public force, then they don't advantage. I think it doesn't correctly explain. There is a problem there. In Lagos, we have that's what we take to do. So you need a thinking that this one is really an agent of the implementation of the different laws and many things. We also recommendation of the official abilities. Other line, we can get and it states that the moment because the police will have the crime one more thing we have to make is government have time and the police have use right to private people. All the people they scrutinize the fire and they have the power to do it. And so if that is done in this way, there's a lot of that behind this and that is the people who have the power to figure out life and then the child is taken. So those who have the exercise to speak about or to do that and the family. What actually if you can understand from what you have to do, and the right of people also the ones that are going to provide supervision from the all members is funding the function of lawyer. Now you have to make in give back day you have to plan. You have to try to back day you have to simply do that. You try to back day arriving where it is a this time. So let's say it was all actually found the person. So if the man has committed because of the harm, in the try one day you can try to go after. The second thing that day is where you not committed the crime, you not know for the 10 years, and you are going to do all of that are not over. And also, you have restorative justice. Restorative justice is a situation where the complainant and the defendant, both of them will go to the you are there because the restorative justice. So in the state of crisis, and delay in the justice. And sometimes you will not need to find the great matter. We don't care the case of the we can't have something to the court. So that's not the meaning of the criminal offenses. It's been a very insightful session. Yeah, we are really open for the adoption of criminal justice law in the state. And I can see my observation is that we are taking insights. By the time we get to the discussion, we now open it up and agree on the way forward. We appreciate it for your patience all this while. And now it's time to call the tea break. We have about Shabbat who will lead us as we approach the 7 points. Mr. Alabi, I know that you are not to be seated, certain where in the city, and the ushers will lead. Us as many times as possible, and not many all the day. So
Ushers, secretary for the dignitaries, the judges, and all invited guests should please be attentive to where they are seated. DJ, we want to treat us to some very beautiful music. General, Lord, members of the United Nations. This will request that the Senate should please wrap up as we commence the discussion panel. We have our panelists here present, and the most important, the moderator, is also here with us. We will please request that we wrap up in the next 2 minutes. The serving of the tea. The tea is already extending into lunch, so we have to just wrap it up immediately. Now we appreciate the patience of the judges of the state judiciary, and my Lord, yes, the keynote speaker. We thank you very much for your patience. And this is important to also state that this is going to mark a very long-term turning point in administration of criminal justice in Ekiti State. And on the side, as we were taking the tea break, we've seen a number of lawyers talk to me about the last session that we had, and I told you that we are really interested in what is going on. And the opinion that we guided along the various lines that we have the official part. We have the police, the lawyers in the police, and the law enforcement, we have the law enforcement, because the law enforcement we also do the international center, the NSCDC. Then we have lawyers in character. And the most important thing, the one that starts for me, the colleague who said, every one of us in this auditorium will one day, no matter the office you want to plan, will one day become private students again. And we should keep looking at whatever we're talking about from the point of view that from pay to be used against our competitor. There is another point of view that why are lawyers seriously against the use of complaint? Because by the time we look at completely, we will discover that the people committing offenses who should not be working on the street, we see that they will be working on the street, and who knows the next people. There is this other perspective that why not try as much as possible to review and make it a situation whereby only the high court will handle proceedings that relates to from pay. That is the committee. I know that our discussions who have been showing from different things of our walks of life, because we on the discussion we have EK identified an academic which also came to practice, and we can actually call it the defense model. We have a CFP Marcos, Ola Ogundon, the veteran, when it comes to policing and crime busting in the state. We also have the United Director of Public Prosecution, Mr. Julius Ajibare, very efficient and strong prosecutor. We may have joining us online, Nancy Dario Akinada, who is also given to practice of law. And then you have the last one on the list, Ashion Oyedele, who is representing controller of prisons in Ekiti. He is the deputy controller of prison. And on this note, we shall join us to welcome the moderator of this portion of the panel, Professor Damilola Olawi, Senior Advocate of Nigeria, international scholar. I can't believe this citation. You will see that we have taken our time to come up with this system. Please a round of applause as we approach the podium. I must welcome online Professor Olawi. Yes. May I request that you academics have to stand up while the selection is very rare. I would like to apply it. Professor Damilola, Professor Olawi is Senior Advocate of Nigeria. Is an international lawyer, policy advisor, professor of law, and recognized expert in natural resources, energy, and environmental law. He has provided expert advice and opinion on oil, gas, and renewable energy, mining, agriculture, infrastructure, development, and clean technology. In North America, in Europe, in Asia, in Africa, and the Middle East. He is the Deputy Vice Chancellor, Chancellor Fellow, and Director of the Institute of Oil and Gas, Energy, Environment, and Sustainable Development at Babalola University. He also is the Chair of Environmental Law and Sustainable Development at HBDU Law School, where he teaches energy law and environmental law courses. Professor Olawi has published several influential journal articles and books. He has been an expert speaker and commentator at several international conferences. His recent publication, Environmental Law in Arab States, Oxford University Press, 2020. CA 2023 American Society of International Law System, American Law System. We keep reading and reading, we will not leave this specific. Professor Olawi holds a doctorate in energy and environmental law from the University of Oxford, a master's of law and LLM from Harvard University, and another LLM from the University of Calgary. He has been admitted as a barrister at solicitor in Alberta, Canada, Ontario, Canada, and Nigeria. And he became a senior advocate. And this is very important. He became a senior advocate at a very young age in the year 2020. That is we are not welcome. The procedure for the discussion will now be moderated and coordinated by the others. Thank you very much.
Thank you very much. You know, try my best to lead not the start today. It's obvious that the start of today's show is in the Lord, who gave a powerful lecture. And when you hear the comments, you see everyone trying to comment this keynote lecture. So the academic in me is asking my Lord to please give us paper so that we can publish it in our journal. That is my prayer. I hope my Lord will grant my requests. But I must bring the compliments and greetings from all of us at the University. Most especially, of course, and Deputy Chancellor of this. So I bring the warm greetings, most especially from the principal, who is a member of the Ekiti. They are aware, part of the SLN. He sends his greetings to the Attorney General. And of course, I must congratulate the Honorable Attorney General for hosting such a timely discussion on criminal justice. We really appreciate the opportunity given to us to comment. I'm a member of the Imperial Branch, so I'm really proud of the wonderful opportunity. There are many layers to the wonderful keynote lecture that we will delivered. And so we will continue the discussion. Of course, when you look at the administration of criminal justice, there are the first thing that came to my mind as I listened to the keynote lecture is the need for us as academics to even change the way we teach criminal law, right? To reflect some of the contemporary challenges that we are seeing. Another area that has not been discussed extensively, which I hope our panel to look at, is the role of artificial intelligence in the administration of criminal justice, especially the ethical use of AI. The other day, it was in the news that a lawyer in Canada filed a wonderful brief in the criminal court, and everything seemed to be going well until they discovered that the cases were not correct. The AI just generated random names, and it became, the lawyer was referred to the legal practitioner disciplinary committee over there to explain what happened. I know we will soon face these challenges in our context as well. So we will look at some of those issues, ethical use of AI, the role of technology, the digitalization of the administration of criminal justice. I have with me a very, very distinguished and eminent panel that will unpack some of these issues. And I will introduce them very briefly. I have Oyedele Ashimbi, who, and I will please welcome him to join me on stage. Born over 5 decades ago, he was graduate of the University of Ibadan, Deputy Controller of Corrections, and of course, he has served extensively in Kebbi State, in Sokoto State, in Niger State, even in Ilorin, in the new custodial Mandala prison or correctional center. And he's going to be giving us extensive lessons on the administration of criminal justice based on his practical experience on the field. You are most welcome, sir. Of course, one thing I really appreciate about this event and the effort of the Attorney General is that they have carefully introduced academic perspectives. Most times when you go for this event made up of practicing lawyers, you hardly hear anything from those of us on the other side, teaching you and training you to become who you are today. But I'm glad that we have on our panel a distinguished academic, Dr. E.K. Adetifa, a member of the fourth set of the Faculty of Law at Ekiti. He also holds, I hope you join me on stage, Dr. Adetifa. He also holds LLM Master of Laws from the University of Ibadan. He's a former state counsel of the state justice. And of course, I have a PhD in this area at Exos, currently an associate professor at the Faculty of Law of the Ekiti State University. You're most welcome. We also have with us in this panel CSP Marcus Ola Ogundola, who is a crime buster and a seasoned police officer. He has served in different capacities in operations, in the administration of justice. He's worked even with the United Nations at the mission ground in Kosovo, where he was awarded the United Nations Medal for Service. He has attended the Lagos State College of Education in Lagos, as well as Nigerian Staff College in Plateau State. He's an active member of the International Association of Chiefs of Police, a fellow of the Institute of Security, and he's completed a number of courses in peace operations. So evidently, he's also an author. He's authored 3 books. So he will give us both practical perspectives and academic perspectives. So I'm going to start, of course, from my immediate left and ask this question. How can we? Yes. Uh, One minute. So we're going to take a discussion format, but I'm running short of. Okay, yes, we're going to use lectures of the seat over there to bring in our last panelist. So unfortunately, he will be sitting far away from us a little bit. So we have our last but not the least, Prince Julius Adibare, who will also be bringing practical perspectives. Born into the Aditoye area family of Ekiti, he commenced his education at Luke Anglican Primary School in Ekiti. Did the high school certificate there. Of course, he obtained his law degree from the Ondo State University, now known as EXU, where he admitted with honors. And of course, he also holds a master in law from the Department of University. He's done his youth service at the University of Scotland before joining the State Civil Service in 2001, where he distinguished himself in the Ministry of Justice, serving in the Public Relations Civil Litigation Department. He's also served as legal advisor to the Board of Internal Review, personal assistant to the then Attorney General by Ekiti, and he has held a number of positions in the civil service, being the Deputy Director of Civil Litigation, and ultimately holding his current role of Director of Public Prosecution. His CV is longer than mine, so I will briefly it there with your permission. And I hope you don't feel too far away from us. I think since you are in the civil service, you will understand the issues with public prosecution. Perhaps you can start with you to tell us how we can implement some of the practical recommendations that have been made today. What will be the priorities if you were to set the priorities going forward? Thank you.
The Honorable CK, and Lord Justice Legal, all the judges here present, including Justice Malushi, one of the mentors, who surpass cross, sometimes it's to play in a mission. I also recognize my boss, my principal, Ilane and your partner STA. Then my ST and PAs, my colleagues, I recognize the Police. I thank you for coming. That showcases the fact that today that we are making an issue in the annals of criminal justice in the state. Before this thing, we start attention to the kiddo speakers
who has dealt extensively to most of the issues we are about to discuss. Now, like my Lord Justice Family said earlier, and my providence Justice Family happened to be my boss, the boss of past to be at the was somebody in the Office of Justice before he handed over to me in 2019. The administration of human justice system in the state has been a wonderful experience, especially since the enactment of the administration of human justice law 2014 and the subsequent amendment in 2022. We all know that the purpose of those laws in the criminal procedure law of 2012 and 2017. Now, are we in the stage where the criminal procedure left us in 2012? My answer is no, Mr. We've taken a leap forward in advancing the cost of justice through the addition of criminal justice law 2014 and amended in 2022. There are some innovative provisions in that law that has not sought to the state in find ourselves now in the addition of criminal justice. The first one I want to really mention of is the discipline of the street magistrates to be connected to the detection centers of police station for the purpose of supporting the records of the records. Of their residents, go and order that into their reign forces. Then regrettably, that provision said that is 1 year of that administration of human justice law as amended. We've never been able to activate that provision. The provision was only activated during the COVID era when the chief administrator said, chief administrator, now my Lord Adekuni, led some magistrates to the CCID to fetch complaint. Since then, nothing has been done in that behalf. And to simplify, at that period, many suspects arrested and custody were released through that process. It is limited to that time, but it has been done in that way. Two, we all realize the state of helplessness and the COVID foisted on the legal practice in the world during 2019. The Administration of Criminal Justice law as amended in 2022 needs provision that cases can be had through audiovisual procedure. Well, the artist today sometimes around the center. I think my Lord, the artist today was a way to a certain place.
through provision. I was fast. I was immediately to the position in that farm. And looking at this scenario, I think the time has come that we cannot even on the way from this system. The inmates and correctional center, they are there now. There are some scenarios that they cannot be brought to solve. When the honorable attorney general, yes, and the one said, this is said that correctional center stop last year. We were thinking about, we were companion, seeing some images that were about to do. Let me start out with. Before the attorney general took it over himself to reduce the situation and the quick intervention in that CCA on 20 November is facing with that style back to the worst scenario that can happen in that correctional system. Now, my mother was going to discuss something earlier on that just this Friday, when he said that thing to me on my WhatsApp on Sunday, I would have found everything by least from a medical center who was on this show. I think the problem we have in it is not anymore, is the implementation. We can follow suit and do what is expected of us and bring this down to the state. The law is here, they are just getting, we are to activate it and put it to practice. Anyway, they are talking now for the by the law established or the Institute of Human Justice Committee, which has been in our law since 2022. In 2014, that condition was never in our law. But in 2022, when the law was created, that condition was floating. The court was obeyed. Nothing has been done in that regard. And I happen to be one of the vocal members of the DPP in Nigeria, but I don't have this. I implore the honorable Reaction System with my boss, the honorable Attorney General, to do something very quickly in that respect. It is another way for us to decongest that principle and to have the criminal and the administrative justice system working as it ought to. Again, I want to say that on this of co-compare, Section 3 is quite different from the provision of the Administration of Human Justice Law. It's still different from the Administration of Human Justice Act by that provision. But in that aspect, we have to enjoy the police. They are trying within their own ambit. Then the investigation at the criminal level is a problem for the prosecutors. Some of these suspects who confess and the criminal level before the come to state ID or IRS. Most of the statements from those criminal level, they are not even to the public. Two, I've had instances of sending back this file for the city when some of these popular statements, they are not people signed by the police, they are not people signed by the police. So it's a problem. And I think they are going back to the general organization. It is another way for us to judge law.
on how we can make this law work as also. Last thing, before I hand over the the issue of I still go back to that speak. My God was found on me as judgment. It's a divine proceeding. It is not an arrangement. And so, in the case of Patigi and Chelsea, 2007, the Supreme Court has laid down the benefits of humanity. And if you look at our own law here, it is not, we have avalanche of provision that is the defendant has their own people. And we are accepting it. The law says 30 days, we know. Section 4 and 5. The law says 30 days, we if the DPP is not returning people advice within 90 days. The Bible says that the power for what the DPP to question. For giving this thing, why the legal advice is not in his thought. And we give sufficient for that. We say, whether we know of 30 days. If you are not doing it, the defense counsel is at liberty to find most of before the magistrate. It has always been said that honorable justice in the law. But are we making use of this provision? No. That law says only capital offense that granted of the because of the capital offense, there is nothing they can do. In granting the capital offense, they are not there. So the moving from there, there are sometimes in that collectible center, as I said today, if they are released, they can be turned upside down, we need to keep our banana. I know what I'm talking about.
Grace. I know you are a lot more. Okay. But I'm mindful of time, so we'll come back to that point. And I think you touched on a very, very important point, which is for us to ensure due process in the way we investigate, the way we pursue going forward. And I think that would be a good point to bring in CS to Ogundola, who is a crime person. And I know that some of the issues raised are very controversial these days. So you wonder, was there due process, was there ethics in the way the crime was investigated, in the way the alleged person was arrested, those sort of issues. What is the international best practice from your experience with the UN and generally? What are the points on this? Thank you, sir. It's coming to stand on let me start by saying that I am not police PPR, and whatever I'm going to say here is going to be on my experience as a police officer, as a crime person. Because I am not eligible to speak for the police. So, I have listened to videos given by my lord, and also listening to the comments from other people. But surprisingly, people are mentioning how to remove or to cancel Funke without thinking of the aftermath of the cancellation of Funke. What is the purpose of arresting suspect and
bringing the suspect report with complete. The purpose is in two folds. One, to enable police to finish its uncompleted investigation. And two, to remove the dangerous criminal from our community. And within and from on the 2nd of January 2025 and then 4 April 2025. We have I need the RS have arrested 165 suspects. And out of this 165 suspects, we charge just 25 in complete. Then, ordinary charge, we have charged other suspects, ordinary charge. The suspect we charge ordinary charge plus 1.2. Can you see the difference? So we are not just charging people on K. We are charging based on the gravity of offense committed by the suspect directly. We are not madmen. It is true that our duty is to prevent life and property. And that's what we are doing. Sir, in Ekiti State, if we try to cancel from game, it will be amounting to what the Inspector General and the Deputy General of Police needs to start. The former Inspector General of Police border the language, the word SARS. And the result, the aftermath is what we are seeing. So, now, sir, the suspects that we arrested and used to charge with from K. These are the suspects that committed serious criminal offenses like kidnapping, armed robbery, rape, burglary, and stealing. We have never charged suspects that committed simple cases, minor cases, such as stealing, one bastard and one bastard. We have not done that. The suspect that we charge should be the first thing that you get on the street of the state. You will not be able to see it of white clothes. For example, sir, let me mention some names. We have one Adeyeye aka Black Jesus. Black Jesus was behind the killing and his cohorts. They were behind the killing of POS operators in Ekiti for 4 months. All of you know what happened during that within that 4 months. Some people find it so difficult to come out in the afternoon. 6 o'clock you not see people on the street of Ekiti until we work seriously. And our concerted efforts resulted in the arrest of these hoodlums. We call them unknown gunmen before you are arrested. You want us to just charge those people with ordinary charge to migrate to be prosecuted? It's not possible. I can listen to Reverend Father Akibade. I'm sorry to mention this. In 2014, November
30th November 2014, that was the day in Ekiti, where a lot of women escaped from the prison. Immediately, the afterwards, going out, they were coming out from the prison, they were committing offenses that they were arrested and charged for. And raping, kidnapping, and robbery. One of their victims was the Reverend Father that just stopped here, Reverend Akibade. He is here. He's going to be here. Will Reverend Akibade be happy that we charge people like that to court? People like, let me mention their name. I have their name here. People like Big Gaddafi, and woman. Sandy Buleye, Jonathan Otto, and 7 others. They were the people that kidnapped Akibade. Ajobi, the fish seller in Ajobi, professor from the University of Ife. Okay, it's a professor who was kidnapped. And the driver of that professor was murdered by these people. And so on and so forth. These are the people we are targeting for. And I think nobody can say it here that find somebody that committed minor offense to court it for him. So my humble opinion is that if there is excess in using of the authority should use their initiative to correct this, to see how it will be corrected. Then removing complaint completely will cause problem. Not to the police alone, because I can listen to former police our former yes, I can listen to him. He said police. No, it's not for the police alone. It's for everybody. Me that I'm sitting down here, everybody here perfect. This okay is our savior. It's our savior. Please don't let anyone think of if you are thinking of Ethiopian that compares to us. That's the joke of a very big mistake. We should think of what we are getting from Kobe. It is something that is helping us to keep the streets clean from being from the criminals. As we are talking now, Mande and the forest, they are combing the forest. And when they come back with kidnappers who have been kidnapping people, by Sakibari can be anything. He's more reading our case files. He knows what he has been seeing now. Sir, as the lawyers are castigating us for using complaint, me, I'm having complaint against them too. And I come up with my complaint. Sir, I don't know how it can be heard. I don't know the law, the section of the statutory book that is supporting the counsel to the accused side to have the copy of the statements of our complainants, the statement of the witness. I don't know if that is law because no one knows lawyer. I don't know if that is law. I don't think that is a law that is backing them. But sir, it's a big mistake for doing that. Very, very big mistake. No, yes, I will tell you talk. The mistake is that the Attorney General can be in the place.
the DPP are playing two business. The DPP and its workers, they know what they are passing through before they can produce, before they can bring the witnesses who gave us statement in the religion. Before they can bring our complainants to court, they know what they are passing through. So complainants, we go and arrest them to come and give their witness to come and tell the court what the will happen to them. Is that proper? And the reason is that after giving the photocopy of the statement of the witnesses and the complainant to the lawyers, they will use the phone number, the address, and everything. They will be threatening them. They will be threatening these people not to talk to court so that they can win their case. They have forgotten that winning their case is not enough. What of these people coming back to the streets? Please, they are getting tired, though. They are getting tired.
Thank you. Thank you very much. Good morning. I think CST has highlighted a number of issues, and I know that there will be time for discussion. I think the DPP and CST have focused on the prosecution aspect of things. So perhaps we can move into issues of crime prevention and correction as well. Right? So I'm going to hand it over to our officer to talk about maybe some of the challenges relating to crime prevention and the changes that you would like to see. Thank you very much.
When you are talking of criminal justice system, the corrections is the last six. Sorry, I'm representing my principal, the person of Tolo Shaga. So, going by what we are discussing, because of the little is in its structure, very information and that's much on my area. But nevertheless, I will see one or two things to ensure that what we are prepared for is being justified. We are only talking of police, whereas we are talking of the crime or criminal whatever starts from our house. How do we deal with different people before it grows up to the level of going into the past? As parents, how do we handle that before it escalates to that? But if you cannot handle it at that level, that means the police, the Minister of Justice, and the political class for you. Like today, nationwide, we are having about 80,000 behind the wall. We are having in our facilities as well that in the country, which is 236. Well, let us now discuss to Ekiti State. Ekiti State Customer Center has a capacity of blocking 324 units. But as at this morning, I am blocking 782. As at this morning, the number of OTPs, are supposed to be going to court on daily basis. That today having 513. Thank God Ekiti is having the Justice and Commission Center. say that moving on to work might not be all that task for us. Honorable Justice Oshodi said in Lagos that we do for 2 days. Going back to 2015, in median, we are working over 3,000 units. That's what we are doing in Lagos as we is working now. Because in Lagos as of today, we are working 2,000 plus per million. Where we are working 2,000 plus as far as 2020. And how do we correct this? The government has come to a level at which the business system has been split into two. We have custodial centers and we have non-custodial centers. The custodial center will lock up the inmates. While the non-custodial we ensure that some offenses are not get to the custodial center. And all the justices should be like motion to lot of the authoritative justice. Mentioned in the he even said that the person might be sentenced to 2 years imprisonment under community service. Whereby myself or my staff and the offender and the complainant will be supervising the abuse with the suspect. Where is in community service? We have our own. We have provision. Through which all these offenders can be perform their sentences. Today, we have a lot of challenges in making sure that criminal system, justice system is being done as expected. At the cost of reaction the other time, I think somebody said the enemies are the suspects are threats and not terrorists. All the other judge or magistrate, an accused will be presented. That accused has to be fair to the law before he gets into the court. In the past, they prepared their food overnight, but there are some problems of which they should prepare their food. They do not before they leave the court, they leave the custodial center. And you see, very many staff are not resistant. That there's no balance for them to see. Very many of them comes from town. Some are from the staff from the market. Some from the parent and people these universities like that. Before they came in, before the inmates came, and people is not on our side today. Another dimension. You see, logistic give us a lot of challenges. Like I said about 256 facilities nationwide. This logistic issue has to be on the federal government. We will be going to the court. Breakdown over the others. There was a particular day. We have all reports that can they help us with another thing. But mind you, the incarceration or whatever is now through a 9 months. It is now on apparent list. The state government should not come in to help in providing logistics, providing some other equipment for us to ensure that our service is not to be. Again, when we are talking of corruption, and armed robber, somebody steal a cow or fowl and is being hurt with armed robber. What do you expect? So the classification of inmates is not well done. In a situation whereby I have to log 324 inmates and I'm logging 782 in the same facility, in the same area. It was when the building, the cells, they're supposed to accommodate all these lives. It's not a place. Ordinarily, we should not keep the robbery, with ordinary activities. That is one. We should not we should consider the age. Somebody 30 years downward should not be compared to somebody 40 years upward. Not of the possibility that is no other okay. We have to manage that work. In this wise, if you have to do what is expected of us critically, we want to appeal to the state government, to those people within the social system, to come to the aid of the correctional service, so that if some buildings are built new work, to definitely the aspect of classification, the aspect of looking at them very well, will be okay. In another dimension, justice social sets the open university is treating very well of this. I have almost forced me. I think the artists for paid now. In fact, that's the masters. But here, what are we going to do today?
So, can we have one house, please? There seems to be a lot of noise. Yes, exactly. Our officer said he will answer all your questions when it's done. So please follow him. Thank you.
So when we are talking of rehabilitation, reformation, and reintegration back into the society, all these things has to be put in place. We have sessions whereby people is doing land, tailoring is doing land, shoemaking. If you know that your great person is not okay for formal education, you can go into formal education. Those who will very many of them are in NC classes. We are appealing to the public health, the NGOs to form a community team to teach them over there. In the past, every year to register inmates of the police, medium, and maximum. They register them for life. And immediately they pass, they graduated into the next class, which is NCA or whatever. So through that, the reformation continues. Another perspective, the criminal justice system, starting from royalty benefits. A suspect was convicted and he was referred in jail time. After the expiration of the jail time, how do we work on jail? The social stigmatization within the society is very alarming rates. I don't want to see it. I don't want to see it. I don't know what I was saying. There was a man there was Pharisee. There was Pharisee. You have to take it to specialist hospital. At that point, nobody is funding. Even the government is not funding. At that point, you have to cover the family. Do you know what the family tells me? They say, at your direct, I'm sorry for that language, but I just want to express it straight away. How do we welcome them? How do we treat them? If actually we want them to change, we want the society to grow from what it ought to be to what it's supposed to be, how do we treat the offenders within our midst? Do we give them love? Try to give people that are from thanks to them, we do. There are some NGOs that visit them, reach them, talk to them, give them hope. But you and I, how do we work on them? How do we give them hope? How do we tell them what they are doing is bad? What is said? We need to blame on the police. However, they have their own processes. In the society, we have a certain set of people. They will be after the report, they will not be following the the families of the suspect. I announced the next court that come and do the witness. If you dare go, I will make sure I kill you. It happens. How do we treat that as so that those are the questions we need to ask ourselves. If what the criminal justice system to be as what is in a situation whereby the head of the society, I don't know what they call it here, and also they call it the one, maybe the bandit or the head, that society or that area. You have communities, you're supposed to have campaigns there. If actually you get to do that, somebody is placing the power in that community, how do you handle that? Because the religion of avoid what they do in society, they are criminal of into our society. Yes, we are missing it. Society is one part, crime is one part, and the religion is another part. So we are missing the religion of this society. Automatically, the system will collapse already. The NBA president. We can come together and settle immediately. How do we pay the money? What can we do to help the youth to know it to pay the the power force. Now, the one in this community, I want to show you that how power they do because we really exist. And then if you want to establish this one, if you want to rehabilitate them, reform them, and to get them back into the society, it is a job that we need to do together. Thank you. It's a job we need to do together. Services back. Like this simple one here. Forget that today they are dead. They have done something wrong. Tomorrow is coming. If they are exposed, if there is wrong, we will be together. Tomorrow is coming, we will keep together. Thank
you very much. I think I'll stop there because of time. Thank you. I know that my officer will get them shared giving us a number of points on corrective justice, especially the need for restoration. We need to prevent crime, and we need to rethink our values as they support a society that is free of crime. And I think on that note, we can pass it on to our practitioner, or should I say our scholar practitioner, both an academic and health practitioner. Because we heard a lot today about the role of legal practitioners in the criminal justice system. And I know someone once said, if you want a crime-free society, first thing you need to
Okay, silence. The law will have it. Take the law of human justice. Cannot be perfect. It's a law that was made by the Lord of prayer. So we're here to talk about the words that we've observed in the appeal of this law. Yes, in doing that, I want to say to you, function of the moderator to give you a kind of guidance, kind of feedback, to be sure and come to the question of the mind. This was okay. Lots of no need to prepare because members of the came in our justice system. And talking of the we should ask ourselves the ethics of this okay. I will say that Lord is okay in kind of job of police society. What is the message of this okay? As we know it, it's just the body side of life. Like I said, our money it is another. Will people education to see that the military is certain specified circumstances. There's last structure and it not to be. If I go to the type of this cover by the founded running public, at what point do I not right that conflict? If somebody runs the public as a case, okay, if you know. And that's the definition of position. No, the woman alone is having pregnant. Instead of one is pregnant or she's not pregnant. Permission to try a place or it cannot even to try a place. And we should be mindful of that. Instead of what donated by statute. It's by statute. The statute has offset the children of God. Over a particular matter. At one point now, that same word that have been most legally constituted to try the particular offense who might not admit someone to pay. Because admit someone to pay and not to decide on the mission. If I'm not doing that, I was saying that the essence of complaint is to bring the standard of paying the complaint of police investigation. And Sabi, because the law of force in China, the law is so explicit as the people of forgave, you look at one of that kind of thing. It's not that it says that any issues of people advice, simply start. It's not any complaint of a police investigation. And more importantly,
Why must the police bring somebody to court when there's going to be completed? Why not bring somebody to court? It is believed. And again, looking at this campaign, are we saying that the offenses cover? Are we saying the offenses cover are just heinous offenses that the magistrate cannot exercise discretion, or they are just offenses that the police will give or giving the total of from K? That's the question. And like Mr. Marcos has rightly asked the other time, which I'm going to answer now. He said, why must we have a situation where statements of defendant will stray to the hands of lawyers? They are public documents. They have right to these documents. They can apply for these documents and obtain them formally. And the game of trial, criminal trial, is not a black market. The defendant is entitled to know and be prepared for his defense through his counsel. So you cannot just see you are holding it. It's not a classified document. It's not. You are obligated to release whatever asked for. Then when you look at this from K, he said the magistrate and inside discretion. But let's add the magistrate who are here. When are you going to come out from your comfort zone, from your facility, and be courageous enough to give effect to from K? If the law has given that latitude to exercise discretion, except a capital offenses, and from K is before you, and perhaps the offenses for that from K, they are not offenses who take a capital offenses. The question is this: why are you so, if I'm allowed to do this now, with respect to your worship, why are you so timid to now invoke relevant provisions of this from K to give them to grant them where is so desire? And more importantly, fundamentally speaking, from K is brought on basis of expert application. And in that expert application, there are type documents, statement of the defendant, statement of the victims, this religion, so it means that the totality of what the magistrate needs to look at for exercising inspection as to whether to grant it or not to grant it, they are ready before the court. It's a requirement that while taking for K, file expert application, you must establish, you must attach the statement of the defendant, you must attach the statement of the victims, complainant that case may be, then perhaps the report of investigation. All these are before the court. And that section 264 now grants indulgence to the magistrate to make inquiry, to look at those things and make an informed decision as to whether or not to assist in from K or not. But in this plan, our experience have shown that the magistrates, they are unwilling or reluctant for written based law to them to either look at the documents attached and take a decision as to whether in this circumstance, given the evidence or the primary evidence as revealed by either the statement of the defendant, the statement of the complainant, and police report, I can rightly and safely to assume the decision to say, look, this one does not fall within matter that I want to decide this over. So by the time they are able to do that, the noise and the activity that from K may scale down to using Western. But until that is done, I want to say that from K deserve nothing but a quiet area. Then the other part that we need to look at, I had an experience where I filed a bail application before the court, before the High Court, asking that my client who have been reminded of 4K be admitted to bail. And the judge said no. I said, sir, may I know why your lordship is not disposed to even hearing this application? But the judge said, don't even bother moving this application. I'm not going to grant it. I said, sir, may I know why? The next man said, there is no formal charge before the court. I was afraid to agree with my lord that, as a matter of fact, at that point, there was no formal charge before the court. But based on the application, the expert application, and the positions in supporting affidavit. Instead of debate, I try to convey the court, persuade the court to hear me and exercise discretion. I thought, brings a lot of discretion. But the court said, no, we can't put something on nothing. Since there is no formal charge volume, how do you want now to proceed to exercise discretion or not to exercise discretion on the issue of bail? And I said, fine. If there is no formal application, and my client will be sent to correctional center, legal advice is not coming from the Bishop of the because the place, of course, I was born there, is ever busy. It's a very busy environment. So we are still waiting for legal advice. 30 days, 60 days, nothing has happened. So when I brought that application, and this my client was in correctional center, I tried to go to the magistrate court, and I met a roadblock too. The magistrate, I don't know why. I don't know why. That's the question. I was told together. They were throwing the system in their mouth. They was telling us why. I don't say, if there's no formal charge, and this partnership condition, which property, I would say that was in going to legal punishment. We don't know that political center is going to branch out together or every somebody is there and there's no communication between everyone. You cannot say it's an election. You cannot say it's not. So there is not an election yet, but there are no charge yet. They are not been formally arraigned. They are not been completed. It's the communication between us. It's the minutes. So when you look at it, we are saying if we are coming to that text, or to that way for me, like for pay is a legitimate, then we need to talk to the market that we know are going to happen. We cannot pay except the capital entity. We do the reason. People will not make much noise. But if that's not done, we are still travelers. And people are there 30 days. Like she's not looking at anything. What of people at the end of the day? The defendant is pronounced innocent. How will he be compensated for the period he has been justly incarcerated? So, justice is not only to the society, it's to the defendant as well. So, there is this zone of innocence. He has not been pronounced guilty. It's a personal right. So, there must be area of balancing to maintain, favorable balancing so that don't just follow them. And against her, I'm very sensitive. Why talking about balancing? Contrary to what my brother said, I've had experiences where from pay was used in land dispute EU. Yes, they said they were fighting on land, they saw them using cutlass, matches, whatever, and the next thing we saw was from pay. Where two driver unions are fighting for pay. Where you complain that your wife put too much trust in your for pay. So for pay is at the end of the police. Well, there is this aspect that is not magnetic. I need to say it. Some people are saying for pay is a Basa instrument. It's not Basa instrument. What about Basa instrument? They say it's an instrument where some even private lawyers feel big. So yes, that there's a way they control their clients that if you don't want some people to use against you, you have to do that. So when we are talking about the police, we are not cascading the police. So we must also say things that actually are told to our own area too. So that it won't appear as if we are just being asked for the police. They say it's a personal instrument. Where some lawyers will control their clients that come, you don't complain to be used against you, and you don't block complaint. The only complaint is just your meat, is just your ticket to government road along the correctional center. So if you don't want that to happen to you, you need to do this. And nobody wants to be incarcerated. So in desperation, they have to go around this and that and that. They send the police to is a kind of a kind of conspiracy against them, where they say, tell them, okay, put some amount of money.
Thank you.
We cannot.
Thank you very much. We'll come back to you. We'll come back to you. You have, as a true scholar, you have raised a lot of issues, and I can see that our participants are keen to engage with you. So what we will do is to take a few questions or comments, and then I'll come back to each of the discussants to tackle them. So please keep your comment very, very short. We are running out of time. So straight to the point, and then we'll take 4 or 5, and then we'll come back. So we'll start here, number 1.
Thank you, Energy and other elements of society. Now, I will start reading from this forgiving. If I have a name, I will go to Supreme Court. Decision of this if I did and choose, you need to be visited. With due respect, because it is still an affront to that presumption of innocence. And of course, it's a betrayal punishment. How dare a police go to protest party? I want to hold Ekiti. Make it matter of notice. Because you need to assist the magistrate who could be timid. Motion of notice. The motion will consider it, the statements, whatever, and the counsel to the suspect will be there to confirm suspicion. Why you cannot do this? Ex-party, no. That is too hard. And 30 days. 30 days. For somebody, you don't even know his face. You are doing investigation. You are investigating him. In the state crime, they will be trading you. They will be trading you. They will have all evidence against you. They won't do arrest, then later investigation. No. But in this country, they will arrest us. Put you there. They are investigating. They are investigating. What are you investigating? So see, I'm worried. I want it to please make it a motion for notice. So lawyers can be there to represent them. Number 2 to play. I'm sorry. Number 2 is that the SCJ, Ekiti, ECJ. You need to make it specific. Yes, the magistrate has power. Let them know that they can get bail. Because they will say, I'm afraid, I can't do this. Get it specific that you have the right. In considering this application, you have the right, because the matter of this for saying you can get bail. When you consider those materials, let it fall you by the police that this is not something you can start discussion. But maybe they don't know. No, this was okay. I think the thing is to ensure that is all. Now, my learned friend, I was former MP legal professional, and I can speak for the bar. You are challenging us. Why are they giving you all materials to work with? It's all right. Public documents. At that event, the law is that it was given ample opportunity to defend our rights, including the release of all the materials. How can you are afraid that it's a witness summon? Why can't you issue witness summon against those friends going away? Why can't you ask them? Tell us what happened. You can effect arrest those guys who are intimidating that witness. They are not friends. What are you doing? Why are you doing? You cannot say lawyers doing their work. I beg you, you are not right. God bless you. Thank you very much.
Thank you so much. Yes, we'll take the lady over there. Let's hear from the. Yes, let's diversify the perspectives a little bit.
All protocols to be observed. I have a question. I have a client who has been in custody for over 2 years, awaiting legal advice. Now at the visit to the correctional center, the learned DPP said the case file was not with him, while the police said the case file was with the office of the DPP, and the acting CJ ordered that legal advice should be issued within 48 hours, which was not done. Now I applied for the bail of the suspect at the High Court, and it was granted. But we're having issues in perfecting the bail. Now my question is, if we are unable to perfect that bail, what will happen to that suspect who has been in custody since 2022, awaiting legal advice, no original case file? Is the sword of Damocles going to hang over his head indefinitely if we are unable to perfect the bail? That is my question.
Thank you very much. One, yeah. So we'll take one more in front, and then we'll go to the other side.
I want to thank everyone. Existing protocol. And the diseases here I don't. I want to ask. This is the conjunction of person. In a situation whereby the case is a capital offense, especially in case of the parliament rape, and we know that the essence of criminal justice is for the party, both the suspect and the victim, to get justice. We are the complainant or the victims. The especially with the suspect side. They go to court, collect court appeal that they don't want the case. And a situation whereby police, knowing that we don't have power to compound such an offense, and will still charge the suspect to court. At the end of the day, so far the victims that are not ready to appear before the court. Even if you charge to the court, you will not see them. At the end of the day, the suspect will be and knowing that the party, that is the victim party, they may not even appear before them. And they decided, based on that, to use their discretion at that level. And we discovered that all who are talking, the essence of administration of criminal justice is to show that the suspect, to ensure that the suspect actually commit that offense. We don't want where the suspect will be sent to prison, and we now discover that most of this administration of criminal justice law, they try to protect the interest of the suspect. They try to protect the interest of the suspect. What the Chief Justice are doing to ensure that the victims will also get justice. In a situation whereby a victim, maybe the parent, they come from a very poor background, the suspect actually commit offense. Let me use a case of rape, where a suspect, the victim has been raped, 12 years old girl, 8 years old girl, 15 years old girl has been raped. At the end of the day, the suspect is sent to jail. What is the law doing concerning the victim? That is the question.
Thank you very much. So we have one from the back.
Maybe we stand on the existing protocol. I have just 3 points to raise concerning from K. But luckily, my erudite lecturer has raised the first issue. I think the first thing we must understand is what is the essence of section 26587. The essence is to arrest, and then before you are able to arraign old suspect in custody, it is not for you to arrest and then begin investigation. So it now leads us to the question: how many days will it take you to arraign? If it's going to take you 2 days, 3 days, then there's no point going by way of okay. You can easily arraign within the shortest period of time. But the practice we have is that the police will arrest and then begin investigation. And that is why it becomes encouraging to keep the suspect behind bars for a very long time. If you check the wordings of that section, it only says that suspects are kept pending arraignment. It does not say suspect kept pending investigation. That is one. The second leg of this argument is that a magistrate are the body and soul of section 265. That section will not work well except our magistrate will start the living life. Yes, it allows that they bring the suspect. But there are certain things that must be done in the form. Where those requirements are not met, such order should be discounted by the court. But most of the time, if you check the complaint they bring before the court, need is what they write before some of this information. When the police has failed to provide exhibits to prove that the victim in such criminal case has not been able to identify the suspect and what happened, it clearly means that such a suspect is not ready for arraignment, and subsequently should not be kept in the custody of the police on the basis of complaint. And then number 3, if complaint is so important to our criminal jurisprudence that we cannot afford to remove it, then we must now make provisions for consequential implications. If the police has decided to file a complaint, he is convinced that a crime has been committed. That is why he has brought such a suspect before the court for case. If that suspect has been kept in custody for 90 days as provided, the 90 days people, at the end of the day, the DPP is now saying this suspect has not committed any offense, or the court is saying this suspect has not committed any offense. What becomes of that suspect who has been kept in custody for 90 days on the basis of complaint? So if we have a situation where there are consequences, if as a police officer you have arranged or you have brought an application to keep a suspect in custody, and the DPP haven't reviewed the fact, is of the opinion that this suspect has not committed any offense, then that police officer should be made responsible. When the police officer are aware that there are consequences for abuse of the complaint, and the provision will begin to reduce the offense of the complaint. And in addition, section 9 of ACA so 3 also needs a review. It provides that statements should be taken via video recording. But it also goes ahead to give a waiver that where the video recordings are not available, such statements should still be admitted. I think there is a need for the law to take a specific position. It's either the law says that there should be video recording and save it and echoes to it, or it says there should be video recording, one document taken, it says that and admitted as it is. Thank you very much.
Thank you very much. There's one, yes, over there. All control duly observed. Most of the things I would have said has been given, the skeleton of what I want to say has been placed on the table. But the question I want to ask is this: what happened to intelligent-led policing? When we go by intelligent-led policing, there will be no need. Okay. You have gathered your information You follow the man, you follow the criminal. The arresting should be the last stage. By the time you arrest him, the following day, the man found himself in court. I'm a law enforcement officer. Before I started practicing, my office will say, if you arrest somebody and you don't have detailed information of the offense, and they come back to fight us, you will pay. If you arrest him, let the arrest be the last stage. After we have arrested him, the following day, let the man find himself in court. There's no need for. Then the DPP has a lot to do. One of my officers was killed by somebody. I was doing the case. For 3 months, there was no DPP advice. Then they have to release him. They released the man and he was walking away. I was crying. So the idea is there should be synergy between the police and the DPP. How will lawyers be claiming that I went to police, they said the file is DPP? I went to the. There's no need for the advice. What is the advice? The file is complete. You saw the evidences. You saw all these things. It's not as if the DPP officials are going to field. They should let the advice immediately. Put their statistics together and let the advice come out. So there will be no need for the other man.
Thank you.
So if this synergy is followed, there will be no problem. Then the constitutional section 1 or section 3 does not allow for 1K. It doesn't. Because the law says the man should be taken to court within so hours. And when within so hours is not followed, there is a sharp contrast to the constitution, which is in government. So if we are to be treated, let's treat other people the way we wanted to be treated. The state will use it all. There will be a day that will be Pharaoh that does not know Joseph. And they can use it against their political opponents. So let's make provision for that. Thank you very much.
Thank you very much. So we come to the front. There are two. One. Okay. Okay.
I think the essence of this program is really best practices in the administration of criminal justice. I think we have overflowed the issue of care. I don't think the issue of care is just an aspect of what we are here. Nobody has talked about the issue of case management. Nobody has talked about every leverage of technology in ensuring I think this is exactly. Okay, no.
Just what you for the
if most of the practitioners here read the Administration of Criminal Justice law very well, then we look at the way for the individuals of complaint if it doesn't exist. If you look at section 26 of the ACT, it's fair. If there's a malicious use of for the pay, a party can apply for compensation. So instead of all the noise, why don't the lawyers take up this and apply for compensation?
Thank you very much. I think that's such a ridiculous let me come back to distinguished discussions. And I think I'll start with Prince immediately. I place the discussion so to tackle any of the questions. People are not want to know this. Over to you. Thank you. Yes. I'm not like the neighborhood issues of KK. The honorable is CK, that is CK, as you. I don't see anything
forgive anymore. I go to the question of value. When the honorable artist Jesus said on the center on 28th November 2024, he made the order that Usman Abubakar, the secretary in the rights. Let's back to the state of the I made inquiry to that matter. And it's the family. The order for defendants in the matter as started trial before my Lord this day. And as at that time, we got to the state of defense. When I look at the charge, forwarded to me by a team of counsel, I discovered that the same defendant in the matter, in the same defendants that have fought as a witness before my Lord the CJ, the actual CJ. The Nigerian General made frantic efforts in bringing that defendants, in bringing that a witness, the victim, to whom I give evidence. We left the DSS. It's not up to the technical that's what the DSS is saying here. Excuse me. We left the bed in bringing the woman right from the table. So when I saw the charge, forwarded to me by that house, just supposing me to one already before my Lord the artist, I discovered that already before that kitchen, we brought out on that day, and we brought out on other security watch. It is a very technical matter. So, after July, I started searching to the level. My record keeper told me that nothing of such was forwarded to the ministry. So we did not find it. The other four defendants that matter is taking their case up to the defense stage. So I talked to you when you first made application. I got out my boss, Loremi, and General, we are not opposed to application because we cannot just find it. And the body between my office and the police are now reckoning it is not there. We can't continue to keep the man in the process of the what will we do? And on the other basis, I think we are someone that no oppose the issue because there is nothing that for you to say that the paper is not. Maybe it has been perfected or not, but I'm hearing this as but we will do the needful in a matter of space. That will be the needful. So this additional criminal justice, I can say practically that he doesn't protect the rights of the suspect more than the victims. In fact, the law was enacted in 2014 to strike a balance between the suspect or among the suspects, striking and the victim. It was an lawsuit of the decision of the in the second state. That is the
here, Obuka, but with the victim and also the defendant, is traumatized. It's going to be public. That is here, it is here. How it came about. So it is not protecting the suspect more than the victim. Then, on the legal advice that my brother over here raised the issue. In fact, in 2022, I made people say, I can't be protected. Because of the national discover and that has made it. We discovered before then that the police are somehow tagging or flagging in forwarding against files to the office of the general. What did we do? We are making the law that healthcare nobody is going to do this for we are talking about anyone should take. We okay, what one have. There will be an evidence that the case has been transmitted to the office of the Attorney General. And all these complaints that are filed, no magistrate, they are here. I'm not defending them. They will take it unless they see the stamp of my process officer before they continue to administer offices on the case. So the matter I'm talking about is like the rest of us, like the rest of us, and my cooperation that I enjoy from my lieutenants, the people that are working along with me in the party, and other councils that are taking parts, rather than address of those. I don't think we are not this we are not account this as a government. The government said that we are not pressing us and president said. But we are not pressing us, I'll never press ourselves here. I know that if you use of office today, the sun is so close, especially in the area of rendering legal advice 10 years and the passing of information 10 years. In any day, you prepare and file and issue legal advice. It's the same day that you file the information. It's the same time. It is a day. So, because maybe after this of the Muslim, I know that we are testing. Can you say with all cases sent forwarded by the police? That's all. Like the I'm sorry. When my brother back here spoke about secretary video recording or video representation of the suspects and the time of the recording statement, the statement, and the police station. Well, affect through the SCC of Lagos from Bali to Bali, affect through ACTA, and this of Lagos Act 2015 from front page to last page, affect through almost all these DAs of different states in the country. It is only in the Ekiti state that that only provision of provision is included, and we are waiting for the street. So If you send people on that device, so the case of in Nigeria for and what other place, people of Lagos and identity, everywhere. As of today, they do not get them. They are not in the state. They are waiting for the final decision of the Supreme Court on that place. Thank you.
Thank you. Thank you very much. Yes, Marcus.
I want to comment the allegation of police not using intelligent police to arrest a suspect before charging. I want to say it here now that there is no how a suspect to be arrested without intelligence gathering. Gathering of intelligence is the only thing that can help us to make an arrest. And because we are not Babalawo or Woli, that we know that someone that committed offense is hiding in somewhere in a place. What I'm now saying in essence is that we have been arresting suspects due to intelligent gathering. And somebody said at least at that place that what are we investigating? That question is irritating. If we know the history behind investigation, you will not say that. And the problem behind the investigation, is it the money spent before a suspect is arrested, or the problem confronted when we are making an attempt to arrest a suspect? It is not because of the help of the government of the state. I don't think that some of the suspects we are arresting will be arrested, because we need Ado here to go and arrest suspects in Sokoto, in Kaduna, in this IPOB area in the east, risking our life. So arresting is being down to a state and not just ordinary offender. Really, let me use the word criminal. You criminal, be arrested, and you want us to just charge that person like that. This is a person that was arrested after spending millions of naira before he could be arrested. Millions of naira. Is this transferring of vehicles? At times, I used to travel by head in order to catch, in order to get the suspect arrested. For example, sir, this suspect that was arrested in 2015 because of kidnapping of one Alaja that later fell in love with their daughter in I don't know how this suspect got out of this case. But others like Oruma, Americana, all of them they are in condemned briefing. But this suspect, that's Ayodele, was released after 6 years of stay in the prison. The third day that he was released from prison, he went with others to kidnap Professor Olomofemi Olaofe Nagoye. I will say people like this should be arrested, and I will give them tea and bread to eat, and I will be patting their back so that they will continue to commit atrocity. What I'm just saying in essence is that arresting of suspect is not easy. Prosecution of suspect is even a bit easier than to arrest suspect. Easier than to arrest suspect. Thank you.
Yes. In
the course of the last few weeks, probably somebody will release, I said, in a situation like this, keeping a suspect in the custodial center has to be done to warrant. Nobody can just take in somebody, keep this person from me. It will be a warrant for the sort of communication. And that's for as the public right is the public has the right to tell us releasing the bill. So unless the person is having 2 charges, 2 warrants, if the person is going to release on the first warrant, we will hold him for the second warrant. You understand what I'm saying? Is that what? What is the question?
My question as a police station deputy. Looking at the space CID which has not actually we are, let's say, let's take the case of rape, for instance.
I said my question at the police station level, not at the correctional center. At the police station level, maybe a case of rape, where a man is alleged to have raped a lady, and the suspect confessed that he raped the person. But at the end of the day, the victims, they later said they don't want the case to go to court. Without any police influence, they went to court, collect a court affidavit that they don't want case. And we, at the police station level, who know we have no power to compound such a case. And even if we charge the case to court, so far the complainant or the victim doesn't want the case again to go to court, even if we charge it to court, you may not likely, even if you call it, you will not go to court. Sometimes you even force them, they will not go to court. So my question is, in order to decongest the process, instead of charging the person to court, based on that affidavit, and they will still remind the person in the prison custody, because it's a capital offense. And the victim, they won't even go to court. If can police release the suspect at the police station level, provided they say they don't want the case to go to court and they are sworn to affidavit? That's the question I'm asking.
With your permission, the answer to that is very simple. The law is stated that crime is committed against the state. But then, there is no law without an exception. You cannot possibly crime more than you believe. In most cases, people stay behind the police, and they just come to the court to say, do an affidavit and say, we are not interested. So, even if you charge them to court, and they are not willing to come, the DPP may say, okay, they are going to bring them to court to tell someone, and some of them will not be to trace them. To trace them, they can locate it to a place you can never know. So where you cannot possibly have access to witnesses, then what do? You are limited. You cannot enter witness box and be given evidence. So the moment you cannot get witnesses to prosecute your case, that might be the end of your effort. So if on their own condition, they now settle ahead. I have a similar experience. They settled. And at a point, I was saying, I said, that is the way we want it. In fact, they've given money to the victim's family or whatever, and they have to keep quiet. Because I said, I had no risk of crime than they believed. So in that circumstance, Even though crime is committed against the state, and the thing they say, okay, we are taking them to God with it, you will never see them.
Thank you. Well, thank you very much.
Yes, the body has said this my phone, let me go to on issue of intelligence gathering, that my brother mentioned the other time. There's an angle to it. It takes two to tango. If I don't have confidence in it, I cannot volunteer for them to me. Instances have hand where informants will become their key. So where there's no trust, a kind of mistrust between the police and the populace, it is difficult to have effective intelligence gathering mechanism. Because everybody want to listen. If my neighbor is to drop pushes and his business has not in any way affected me injuriously, I can choose to do the other way. Because the moment I say, this my neighbor is to drop pushes, and I now report to the police, and eventually is able to wriggle his way out of police net, assuredly it will come back for me. The question will now be, why can't you keep your mouth shut? So where there is no trust of confidentiality, that if I volunteer information to the police on intelligent basis, the person against whom I'm giving information will never get to know that I'm the one who has given that information. If I'm not safe, I can choose to look it down. After all, the law is clear that your presence at the scene of a crime does not make you an accomplice. So as long as you do nothing in that crime, so to have effective police, community policing and intelligence gathering, there must be this confidence and trust between the police and the public. Otherwise, if I want my peace and I don't want to negotiate, I can do the other way. Now, coming to the congestion in prison, one of the areas to look at is the need to create criminal division of the High Court. We have cases like my Lord has rightly observed at that time, where criminal cases can be had on daily basis from day to day until conclusion. There's no how we can mark criminal cases. We apply before the court, we know how busy they are. So when we apply for them, we say criminal cases take priority. We know that for sure. But as long as a kind of a criminal court division that is having the responsibility of handling criminal cases on daily basis up to conclusion, that will help to congest the prisons. That will help. You know, there's no how you go to my law court, he has about 10 cases, 5 civil, 5 criminal. He won't kill himself. So these are these, but when we have this criminal division on the High Court that is just to handle criminal cases, we will make fantastic progress. Finally, section 116 of the ACGL bail and impose possible bail conditions. One of the areas that is of concern to me is that the requirement that Shorty must be a civil servant of certain grade level. Shorty must be a civil servant of certain grade level. If you are going to insist on that, it will hamper admin of criminal justice and further congest the cases. When you don't make it a condition, we know for sure that the judge has the latitude to impose bail conditions. But where such bail conditions are such that they are not easily meetable by the defendant, it's more or less a denial in disguise. So when you now say level 17 officer, level 15 officer, and there's no how the defendant can meet such conditions, then the result of hiring civil servants, some of them are not even known to the defendant, hiring civil servants to serve as shorty for them. And what is even the assurance that a civil servant today will remain a civil servant tomorrow? He can resign his appointment the next day, he can relocate for greener pasture, he can join politics. So the experience of making a civil servant of certain grade level as shorty, to me, is inconsequential and should be expressed with. You can, the court has the latitude. What is the end of bail? is just to ensure the attendance of the defendant to stand trial up to finality. Once there's a reliable source, whether it's a civil servant or whatever, in fact, some of the relatives of the defendants may be on better standing than the civil officer. So they will have people who can really stand for them and who may not be civil servants. So
need final words this session.
Final words. The Sunday briefing is what the other panelists were very different from the I've just said. Concerning the issue of representative of Shorty, I want to say this also to us. We are seriously facing a challenge now in the issue of post-training. I want my Lord Honorable to reality before it leaves. There was a political hearing in his court. It has gotten to a state now that 14 in the state. They are camouflaging themselves. They will go out and show another man's house to be their property. Another man's land to be their own property. And the people come with strength, sea of hope. So the world now is touching. So nobody to blame the judges. If they are requesting for the 17 or the 16 officers, it is not easy, especially in capital offenses. I've had experience of going before my loss here in all specific offenses, 260, 200,000 naira, they should be like but in a capital offense, I appeal to the Lord they was the issue of filing affidavits to withdraw matter is unknown to law. Second one, I left is very clear and protected. The affidavit law officer of the state or criminal matters in the state as the basis of the open court to general. Nobody has that power to stop the affidavit to withdraw any matter. In a situation that the defendant has been maybe because of possibility, maybe they are related by law, and they don't want the tribe of the family to snap. Nothing is stopping them, nothing is stopping them from rising a level through their counsel to go to the community of the this is we are. Please stay on stuff. And I think the language is here. Would be some this process. It's from Africa, it's from law to law. But I want to say sorry.
Thank you.
Thank you very much.
Yes, that is our play. One of the things before I am is the issue of witnesses. Witness supports. SPL is clear in section 254 on their behalf that it shall be the business of the chief registrar and my PS and ST But what we have today is that it has been left fully. We don't even know the The other reality is the one alone. Bearing that cross. I think something was done in that respect. Again, of this, we find the creation in the God, pertaining to the benefit of interpreter. Some of these houses who have the own understanding about English. After it was when one of the thousand was to me and told me that they want to pay interpreters. And look at this, I'll be about it. It is not the business of the justice to pay interpreters. Then what is happening today? It is the ministry of justice that is paying interpreters. Except the only one that is appearing before God, the artistic. Others are collecting money. Lastly, police, we are friends. But this one was something we find instances now that what we sit down in our office, patiently, when we bring this case files, please, whenever we are calling upon you to forgive evidence, kindly oblige us. We investigated the matter. We transmitted the file. We perform writing. We be calling you, especially those of the state ID. And telling you now, how the guy is making. Most people in the state ID, they are not operating with nothing of the people. They are not. Again, I'm not in an arrogance. I will mention that to you here. That's the also that in that arrogance, operating. Because the blessing, the concept of age, to write the letter to go to the police, I think that's all. But I won't do it. But talk to them. Talk to them. We have to make this case war. We have to make it war. But doing your own person, you are doing your own person. If I just say that because I'm doing your own person. We have to make this case war. Please talk to God. What are you doing? Thank you.
Thank you. Well, yes.
Thank you. So I want to go back to this issue of arrest of suspects because I believe the judicial system of arrest and doing now is what is making us to be relevant within the police force. So I'm continuing talking about the arrest. Sir, the community members are not usually cooperating in giving us information that can make the arrest a suspect. And they are being hiding under the pretense of this primordial belief of if you give police information, police will go and tell the people that you are the one, Mr. Ujo was the one, Mr. Dada was the one that gave us information that led to your arrest. The primordial belief is not correct. Then, sir, I believe you see that the modus operandi that were taught in a police academy under police science are not more working. We are deceiving ourselves. And because of what? This modus operandi under police funding under police science is not working, it's not more working because of corruption. Let me say it example. Today, nobody is ready to give us information that can lead to arrest a criminal without giving money. We should be ready to pass with money. We are paying money to informants. We don't have free information again. If you want to make arrests, you should be able to do things. There are 2 things you should do as a police officer. You should be ready to sleep in your office. Put extra hour to the normal hour that government is paying you for. Number 1. Number 2, you should be ready to pass with big amount of money, not small money. They will know who is like bank robbery. People will see the perpetrators. They become attackers. Okay? You want us to tell you the person that led that operation. Give me 1 million naira. We give. And there are people that need to collect money from us, and they will not give us information. Then we now be looking for them on camera. They will go and give CP. They say that CP, because they know that CP want to perform. They want to arrest culprits. They will go and pay the CP. Collecting money from the CP that if you give us money, then you go and give market information. Even without calling the CP, they give you money. They are made of it. Nothing. So this corruption is really affecting everybody. That is. Then I have 2 questions to ask them. And I don't want the question to be rhetorical one. I want to ask the question. Number 1, is it a taboo? Or it is against the ethics and law of the practice, the law practice, to help the police in arresting or giving the police information that can lead to the arrest of culprits? Because it is common that culprits will go to lawyer and open their mind that my lawyer, I am the one that put that man. And the lawyer will know that he is the one that keeps him. He will not give him that information. Then after breaking the deeds, after making arrest of that person, the same lawyer will be doing everything humanly possible for us not to charge the justice. We can do anything to catch the suspect. Then the second question. The second question for God. Sir, why lawyers are afraid of communication? When they know fully well that they can use their own practice to honor us. If we find some, we find a child, complete child in court, and you want your parent to get out of the case. Can't the lawyer go to high court to file an application, a bail application to get his client released? Why are they always forgetting when there is another way of getting their clients released?
Thank you very much. Well, I believe those questions will be answered in the conversation over lunch. I don't want our lunch to become dinner. So I think we've had a very wonderful session. I hope you will join me in expressing our appreciation to our panelists. They have discussed some of the intricacies of advancing criminal justice in Ekiti, and we hope that their recommendations will find their way into the community and to be released. So, our Deputy Controller of Corrections, Oyedele Ashinobi, CFT Marcus Ogudola, of course, scholar Dr. E.K. Adetiza, and our DPP Prince. Thank you for the wonderful contributions, and please join me in giving them a round of applause. Special thanks, of course, to my Lord, the acting Chief Judge, as well as our keynote speaker, Honorable Justice Oshodin, and the Honorable Attorney General and Leonard Secretary of ICN for giving us this wonderful opportunity. Thank you very much.
Thank you very much, Professor. That will never allow me. But before we discharge the panel of discussants, we would humbly invite my Lord, the Honorable the Acting Chief Judge, my Lord, the keynote speaker, and the Honorable Attorney General, to please come forward and take a picture of the discussants. Thank you very much, sir. And I wish to inform you that the communique is ready, and the communique will be read immediately after the group photo. Thank you very much, my Lord, for joining us for the group photograph. And kindly take note, my Lord, members of the ITV, that immediately after this fourth photograph, we will be inviting my Lord and other members of the ITV to join in the photos. Thank you to our discussants. My Lord, the Honorable Acting Secretary, please wait. While we invite my lords, all the judges of the state judiciary, and all other dignitaries of the ITV, all other judges, members of the ITV, representative of the second vice president of Nigerian Bar Association, the Dean of Law, whether university or yet. And to present a communique, let us take our move. The double speaking, please join as well. To read the communique, I would like to invite Dr. Taiwo Midoye, the chairman of the branch of the Nigerian Bar Association. The attention is needed now. And please, the ceremony really starts after the communique. Ceremony will start immediately after the reading and adoption of the communique. My lords, we are grateful. Thank you very much, my lords. We appreciate your presence and your patience.
All of them promote in your time. The thing is, this is the abridged community of the state Administration of Criminal Justice Summit 2025. The full version of the communique will be distributed shortly. The summit was held today, Monday, 7th day of April 2025 at Ekiti Hall, with the theme attaining best practices in the administration of criminal justice in the state towards the paradigm shift. In addressing this theme, Honorable Justice R.A. Oshodi recommended that there must be a procedural innovation, encouragement of pre-bargaining, promotion of restorative justice, effective database system, and critical technological integration before the state can attain best practices in the administration of criminal justice. The objectives of the summit was to provide a platform for stakeholders to discuss on strengthening criminal justice institutions, promote criminal justice accountability, protect human rights, and adopt innovative approaches to criminal justice administration in the states. The cities, in attaining these objectives, cities discussants address several issues. At the end of the summit, the following points were arrived at. Please kindly listen attentively. 1. There is need to review the criminal justice system of our head states in the state. 2. The needed review is important and is not limited to legislative interventions, but also strengthening both infrastructure and institutional framework on administration of criminal justice in the states. 3. To achieve this task, a criminal justice committee for the states will be set up comprising of representatives of the following agencies. 1. A representative from the state judiciary. 2. A representative from the Ministry of Justice. 3. Representatives from the Nigerian Bar Association. 4. Representatives from security agencies and other relevant stakeholders in criminal justice administration in the states. 4. The primary objective and assignment of this committee is to examine, analyze, and dissect the paper delivered by the keynote speaker today, and find a way of adopting and adapting that same paper to the prevailing situation in the states. 5. The committee will thereafter produce a working document charting a way forward to attain best practices in the administration of criminal justice in our dear states. Further discussions, further interactions, and further briefing regarding this will be communicated in due course. This is a big version of today's communique and is presented for adoption by this House and further dimensions to be communicated. Thank you very much. We appreciate everyone for listening.
I have the honor and privilege to welcome to the microphone the Solicitor General and Permanent Secretary, Ministry of Justice of the State, Mr. S.C. Parmentier, for the closing remarks. The activity I acknowledge the presence of media other producers states for their patience since the morning. We agree with you that this has been the best service in respect of administration of criminal justice in the states. I know that this discussion will continue. We cannot stop here. From the look of things, I want to exceedingly acknowledge our keynote speaker, Honorable Justice from High Court
Lagos High Commissariat. Sir, we most sincerely appreciate you. That's keynote's address. Actually, a keynote address. It's a necessary. And we promise that this is going to be published in the Assessment of Justice Journal very soon. And we have to because I took through, and I discovered that there's a lot of innovation that we need to put in place, especially in the business process. We are going to do that as regards the justice and justice goals and the community service units. We are going to implement that in the Ministry of Justice. And thank you so much for this paper and we continue to move forward for your contribution, especially to our discussion on the criminal justice of the state. I sincerely want to appreciate my boss, the member of the criminal for this time here, because what I mean that all of us are actually today, there is going to be another in that of emergency. We wrote that. That is why I said we cannot conclude this situation here today. That's why the committee has been like the meeting of the committee that the committee is going to separate between the Ministry of Justice so that we can look at all the areas that we share today to come up with a working paper to implement the way forward. For the Islamic committee, we set up the Ministry of Justice concerning the Ministry of Human Justice. I thank the committee. I thank everybody. I thank the police, the civil defense, the architecting, everybody that couldn't get today to get this situation. I thank everybody. I thank the staff of the Ministry of Justice because not if you know that operated the attorney general, we have this kind of very good boss service. I thank everybody and I wish our guests are a very good and safe place to Lagos. Thank you and God bless.
We appreciate you once again, the Honorable the Acting Chief Judge, the Ekiti State, the Honorable Attorney General Commissioner of Justice, my Lord Australia. I will also be. My lords and everyone, we have to declare and it's time to take our lunch. Thank you for coming and God bless you. See you again soon.